It doesn't matter, sure.
Okay. And nice to see some new faces. So we'll sort of dive in, but let's start with all the administrative goodness here. Roll call first.
Yes, I'll be doing housekeeping announcements today.
Thanks, Danielle.
Of course. Welcome, commission members, liaisons, and members of the public to today's Legal Services Trust Fund Commission meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. To use the raised hand feature by phone, dial *9 on your phone's dial pad to raise your hand and do the same to lower your hand. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. All commission and committee meetings will be recorded and posted to the State Bar website. A friendly reminder that this is a video conference and to please be aware of your surroundings behind you. Zoom captioning is also available. To enable it, please select Live Transcript at the bottom of your Zoom screen, then select Enable Audio Transcription. And then a couple of troubleshooting tips. For those using Zoom on a computer, when on mute, holding down the space bar will temporarily unmute you. If you use your phone to dial into the meeting, please be sure your computer's microphone is on mute to avoid audio feedback issues. And while joining audio via computer is highly recommended. If an individual loses audio, they can call in separately using the Zoom conference number. Thank you.
Okay, thanks, Dee. You want to take roll?
I'll do roll call.
Okay.
Schreiber.
Present.
Al-Sarraf.
Present.
Connolly.
Present.
Aglagi.
Present.
Ball.
Present.
Fightmaster. Blakemore.
Present.
Basheli.
I'm here.
Campbell.
Present.
Escobedo. Galkin. Jason. Iskin.
Here.
King.
Here.
Klein.
Ditchline.
Cruz. Lee. Mahoney.
Here.
Meeker.
Here.
Milrod.
Here.
Morales.
Here.
Vargas.
I believe we've accomplished our first task.
We have quorums. I can do State Bar staff and liaisons.
Yep. Good job, everybody. Way to be
We
present.
have quorum. I'm sorry, excuse me, I didn't do our non-voting judicial officers. Justice Rodriguez. Judge Seligman.
Here.
Judge Yang. And now I'll do our liaisons. Blue Aid Association of California. And
Zach Newman is here from LAC. Thanks.
Zach, and is Lauren? I don't see Lauren. Lauren, okay.
Oh, there she is. Yeah.
Okay. From the Judicial Council, Laura Brown.
Here.
Hi, Laura. And then State Bar staff, Elizabeth's here, Rocio, Erica. Michael, are you here?
Here.
Danielle's here, and Raul.
Here.
Great. And that is everybody, Chris, I have it.
All right, and Joe Lee has joined as well.
Thank you, Joe.
And Cliff Klein is here.
Okay, thank you, Judge.
All right. Yay. Good job, everybody. Thanks for being here. I want to call out Maria, if I can, our newest commissioner, and your reputation precedes you. And I've heard great things. So if I can put you on the spot a little bit, just to introduce yourself to the group. Just tell us how you came to the commission. Just so everybody knows, Maria is an assembly appointee. We have a lot of new commissioners, so you'll have the opportunity, just as all of us are, to get to know you. But yeah, just feel free to take the floor here.
Thank you, Chair. So hello, everyone. My name is Maria Romero Morales, and my pronouns are she, her, ella. And I am the Assistant Chief Diversity and Inclusion Officer at the University of Southern California. And I think I saw another Trojan here wearing a sweater. So I know at least, I know I'm not alone. I'm a former elected official with the city of El Monte. I was a council member for 4 years. And I am always looking forward to serving my community, and in this case, joining you all on this appointment. So thank you for having me.
Well, welcome aboard. It's nice to have you. As a Bruin, I won't hold it against you, but it's great to have you. I want to, oh, get that off, Eric. Come on, come on. So this full contingent today reminds me of the success we've had in filling spots, and just a reminder to work your networks to ensure that the commission has sort of an ongoing applicant pool. It's so great to see the diverse backgrounds of the people who are here today. I just think it really enriches the commission, and the work we do, I think, is much better for it. So I'm really grateful for that. So welcome, Maria. We can go ahead and see if there's any member of the public that wishes to speak at this point in the meeting.
I
State
do
or
not
staff,
see
anybody?
anybody's hand raised.
Okay.
Kim or Shannon, can you let me know? I don't see anybody though.
There are no hands raised.
Great. So we have a full agenda. You know, we always block 4 hours for these meetings, and I don't think the time adds up to 4 hours, but it somehow manages to creep in that direction. So my plan today is to take a little bit of a break if we need to, and if we can, about 90 minutes to 2 hours in. And if anybody objects to that, please let me know. We will move into the business of the meeting, and hearing no public comment, I'll just entertain a motion, assuming everyone has had an opportunity to review the agenda and the meeting minutes from March.
Chris, I'm sorry for interrupting.
Yeah.
We are having a technical issue with the tally sheet, the vote call sheet. Can we move to number 5, the grants administration, since that's all updates, and we'll come back once I have a
Yes,
proper.
absolutely,
I
no
apologize
problem.
for that.
That's okay. So we'll move to number 5 on the agenda, which is a report from Rocio and Juan and Elizabeth. And again, that should be in your agenda packets.
And we just have an oral update, so there are no.
Actually,
Oh,
short PowerPoint.
you have a short
okay.
PowerPoint. Can I go just really first?
Oh, yeah,
to introduce us?
Yeah.
Since there are some new commissioners, I just want to introduce you to a little bit of the structure of our office. So we have 3 directors in our office, myself, and then we have Elizabeth Hom, who leads our diversity and inclusion work, all of our equity work, and then we have Rocio Avalos, who joined us a few months ago, who leads all of our grants work. So you will be seeing a lot of Rocio in the near future. So with that, I'm going to provide just a quick legislative update, and then I'll turn it over to both Elizabeth to provide the D&I update and Rocio to provide the grants update. So as you all know, and we reported at the last commission meeting, at that time, the governor had issued a January kind of a budget that usually happens in January. Since then, there has been a revision to that budget that was proposed called the May revise. And then the latest kind of update that has happened is that now the Assembly and the Senate have both released budget acts, and they're identical in response to kind of the governor's budget. So the governor has up until, I believe, the end of the month, beginning of July, to kind of finalize the budget, but we're very confident in terms of the numbers that impact us, which no surprises, the Equal Access Fund grants that we administer, it's gonna be a base funding at $35 million. So that's not a surprise to us. We did not do kind of advocacy on purpose this year for EF funding. So we're pleased that it's remaining at 35 million. And there's also legislation that allows us to collect filing fees for that. That piece is a little bit unpredictable on how much like filing fees come in from year to year. It's usually anywhere, the statute allows us to collect up to $5 million in filing fees. The last few years have been really volatile with the filing fees. So we usually budget, we work with the Judicial Council to budget amount so that we can distribute, but we've been budgeting more close to $1 million, and then if more come through, then that will get roll back to the reserves. Homelessness prevention grants. As you all know, we first started receiving homelessness prevention grants in 2019. A couple of years ago, the legislature had assured us that we would be getting at that time, $80 million over 3 years of homelessness prevention. So there is a line item in the Budget Act this year for $20 million, but that's not new money. We knew that that money was coming through. And when the commission had released that money originally a couple of years ago, we released it as a 3-year grant on the assurance that this money is coming through. So we're pleased to see it, but again, no surprises. The one thing that is, what we're pleasantly surprised is in January, there was $6.1 million in the governor's original budget for care court funding. That number now has gone up to $23 million for 2 reasons. One of them being that the legislature and the governor are they have upped their numbers and how much they think each case for care court representation will be. And then also Los Angeles County has moved up its start date. And Los Angeles County is about a quarter of the population of California. So for those 2 reasons, that $6.1 million that's in January is now $23 million. We also have a preview for year 2 of care court funding. The next budget cycle will be $52 million. And then after that, for year 3 and ongoing, $64 million. And all of this funding will be administered by the Legal Services Trust Fund Commission. So it's a very, very good kind of budget cycle for the Trust Fund Commission. And we'll talk a little bit more about kind of revenue streams when we get to IOLTA distribution. Unless there are any questions, I'll hand it over to Elizabeth.
So I'm just going to give a brief update on the State Bar's Diversity, Equity, and Inclusion Leadership Seal program. It's a program that encourages employers of California attorneys to commit to and implement various action items to advance DEI in their workplaces and hopefully then in our profession and then throughout California. And so let me just slideshow ready. And so we launched this program in January of this year, and we received 79 applications, 43 of which are committed. So these employers are committed to implementing these actions that we are encouraging them to do so. And 36 have actually implemented many of our action items and will receive what we call a DEI leadership seal. We actually just announced those recipients last week. And so I wanted to highlight that there are several of our grantees and several of the employers of our commissioners who have participated in this program. And so here we have a tiered participation for the leadership seal, gold, silver, and bronze. And so at the gold level, we have Disability Rights California, Inner City Law Center, One Justice, and then our liaisons over at LAC. And then in the silver tier, we have the Alameda County Homeless Action Center, Child Care Law Center, Community Legal Aid SoCal, Youth Law Center, and I believe this is a means firm, Lock and Lord. And then at our bronze level, we have Lisnick, Legal Services Northern California, and then the Federal Home Loan Bank San Francisco. And my understanding is that Bonachet and Jeff are in leadership there. So I wanted just to shout them out. And then we have several, as I mentioned, committed employers and including our grantees. And so we have 16 of our grantees here, as well as Joe's firm, Munger, Tolles, and Olson, and then the State Bar itself were committed to, as an employer, to receive this seal as well. So I just wanted to highlight that for you all, because even though the commission focuses a lot on access to justice issues, diversity, equity, inclusion is really intertwined in it. And I think that we can, as we work together with the Council on Access and Fairness, with the law school fellowships, I think there's lots of opportunities for overlap and collaborating. And so I wanted to just share this with you. And if any of your employers are interested in our next cohort of recipients, you can reach out to me or Danielle, who is leading this program with us.
Can you say just a little bit more about what employers are committing to?
Yeah, so we have 10 action items that, and you can commit to several of them, 5 to receive the bronze level seal. And they include having like a DEI strategic plan for your organization, collecting data on your attorneys and your staff, making comparisons, looking at like attrition rates, promotion rates, who's getting promoted, who's getting advancement opportunities, surveying your staff and having stay and exit interviews to gather information from your staff, putting on your recruitment materials like a DEI statement, and also having DEI work count towards advancement decisions. So whether it's a performance evaluation or attorneys get to have billables towards it, and then also having leadership be involved in the DEI implementation, so from the top down. So those are some of the activities.
Great. Thank
So,
you.
thank you.
Eric has his hand up.
Yeah, I'm just surprised more law firms haven't applied, other than Munger Tolles, best in class as usual.
We have a lot of law firms. I just highlighted the legal aid ones. We have a lot of law firms who have applied.
Oh, okay.
and have received the seal. You can go to our website. We can send the link out after the meeting. We do have a lot of law firms apply. I just wanted to highlight our grantees and our commissioners today.
Okay.
Thank you.
Great. Hello, everyone. For everyone who doesn't know me, Rocio Avalos, as Juan mentioned, the newest program director in our office. This is my first update to the commission, and hopefully you'll continue to hear good things coming out of my reports. As Juan mentioned, and as the commission knows, there's been an increase in funding in recent years that we're responsible for overseeing, and we're glad to have been able to also grow our staff team to be able to support grants administration. So just wanted to mention some of our newest members of our team, who I don't believe are, you may not be able to see them, but I'm sure they're listening. So Angela O'Hara, a senior program analyst, joined us earlier this year since our last commission meeting. Lauren McGarry, another senior program analyst, and Abraham Gutierrez, program analyst, just joined us earlier this month, and all 3 of them are based out of our Los Angeles office. I just wanted to mention those names. I'm sure you'll see them in written materials or in future meetings, so you're familiar with them. So we're excited to have them. And as you know, with more staff, we also have the ability to provide more TA technical assistance to our grantees. And knowing that there are some unfamiliar faces, we are also going to be, in addition to the staff contacts that each organization has now to provide technical assistance based on feedback received recently, we will also be uploading to our Smart Simple platform a directory of staff, so everyone has greater access to who's lead on what, and hopefully be able to provide better technical assistance, and try to also kind of streamline our overall application process when folks are gearing up to submit those on time. Yeah, and I think just wanted to wrap up and just say that in 2023, you'll be hearing more about this in a later agenda item. But the commission would have, and this office would have distributed almost 150 million in awards. And so that's across 13 different active or open grant opportunities. So just to give you a sense of, we're talking about increased funding and additional grants administration for our staff. And that does not include the almost 23 million that Juan just referenced for CareCorp grants. And then also our bank committee later this year will be working on awarding bank grants for the last batch of funding we have, and that'll launch in 2024. So I think, yeah, you'll see in a later agenda, you have in your materials, actually, if you're interested in seeing kind of more of a breakdown of that funding. And I know that Juan and Michael will be talking a little bit about that later as well.
Thanks, Rocio. And for new commissioners, you know, you are emerging onto the commission in like the fattest part of the Mississippi. You know, many of us started when you could cross it like a creek. And now, as you know, we're talking about just a ton of money passing through. And so it's very notable and yeah, exciting, because it's, you know, this is much needed, as you know. Okay, moving on, 5.2. back to Rocio and Michael.
We have some good news, and I'm actually going to pass it to Michael to give an update on our audit.
Yes.
Sorry, Michael, just to, if for those of you who are newer commission members who may not know Michael yet, our program supervisor who oversees our financial analysts and our program analysts who manage our IOLTA program.
Thank you. Hi, everyone. So just as a brief update with respect to the 2022 year-end audit, and just wanted to give you a report that the audit results for the year was a clean audit. There were no management letter or items that were brought up. And then separate and aside from that, for the Legal Services Trust Fund, there is a specific report that was issued, and happy to report that based upon the testing and procedures that are done by the auditors, they did find that we were completely compliant with the requirements for the trust fund program. And so good news there as well. And lastly, we are embarking and working with our auditors on field work for our very first single audit. Field work started request-wise a couple of weeks back. So we're working through the last salvo of request items, talking with the auditor earlier this week. They're anticipating field work to be wrapped up sometime next week. And hopefully by the beginning of July, we would have the single audit report issued to us, but that is forthcoming.
And I'll just add, just for commissioners that are not familiar. So obviously, a lot of foundations do their own audits, organizations that our audit is a little unique in that the state bar goes to actually several audits a year. And some of them are statutory mandate, including the one that Michael just mentioned. And then a couple of years ago, there was a statutory change to require the trust fund program itself to be audited as part of the state bar audit, but we get audited on how we run the IOLTA formula and our grant making processes. So it's several months of auditors asking Michael and the fiscal team they'll pick a random like program and they'll ask us to explain how we came up with that allocation, if there are anomalies, do we have the backing? So it's a very, very intense process to make sure that we are running the formula correctly and that we're doing everything in compliance with all the statute. And we've had a clean audit for several years now, so ever since it started. So really kudos to the fiscal team for that and Michael leading it. Thank you.
I want to shout that out as well, having both experienced audits that were much less favorable in other organizations, but also because the State Bar and the Legal Services Trust Fund Commission are really dealing with so many moving parts and now such an increased amount of money that it's to get a crystal clean audit is pretty great. And so that's an ongoing responsibility of the commissioners. And so congratulations to you and thank you for the work too. It's really a load off when you aren't dealing with issues like that. So yeah, thank you.
And just one last update on the audit piece. So in addition to the single audit that we're going to report back at the next commission meeting, the Trust Fund Commission is subject to one more audit. With the passage of SB 211 a couple of years ago, there was legislation now that says that the state bar itself needs to audit the commission and their grant making award processes. So once that has been kind of done and finalized, we'll also share out a report of that.
And there's no action item to vote on there. Oftentimes you do have to vote on the audit, but I don't think there's anything for us to actually vote on.
There's not, because it's part of the larger state bar audit, and that has been shared with the Board of Trustees and goes through approval.
Yeah.
And for that type, that's the mechanism.
Yeah. Thanks, Michael.
Welcome.
Rocio, anything else? Raul, are you? There you are. Yeah. Why don't I hand it off to you? This is an important update in particular for new commissioners, but for everybody.
All right. Hello, everyone. My name is Raul Duran. I'm Assistant General Counsel in the Office of General Counsel over the State Bar. I will be giving a short a high-level overview about our conflicts of interest and Bagley-Keene. So just give me 1 second while I share my screen. All right. That's right. I'll be presenting on these issues. So I wanted to just talk about, at a high level, the conflicts of interest principles that apply to the commissioners. First, it's that by statute, we're subject to conflicts of interest rules under Business Professions Code section 6036, which is the main substantive provision governing conflicts of interest in California, and section 6037, which explicitly applies those substantive rules to the Legal Services Trust Fund commissioners. The State Bar also has its own conflict of interest code for designated employees, and the commissioners are explicitly referenced in that code as being subject to it. So there's two primary categories of conflicts. One are financial conflicts and the other are personal conflicts. Under Business Professions Code section 6036A, you must disqualify yourself from participating in the making of or attempting to influence any decision that has a reasonably foreseeable material effect on your financial interests. So financial interests include income, gifts, and indirect or direct interest in business entities, investments, and real property. So what that means is the commissioner has a financial interest in any source of income that is either received or promised to the trustee and totals more than $500 in the 12 months prior to the decision in question. So practically speaking, financial conflicts don't come up too much for our commissioners, since most of you are not permitted to be employees or independent contractors of any of our grantees. In addition, most of our grantees are nonprofits, so it's generally unlikely that anyone has an investment in one of our grantees. The one situation where a financial conflict could arise, or is most likely to arise, is if a commissioner has a spouse that is either an employee or a contractor of one of our grantees. So what does come up more often is personal conflicts. Under Business Professions Code section 6036B, just recusal or disqualification is required when you have a personal non-financial interest that prevents you from applying disinterested skill and undivided loyalty to the State Bar in making or participating in the making of decisions. You may note that this is written as a subjective standard, but in the interest of adhering to concerns about conflicts of interest, we follow an objective standard regarding assessments of personal conflicts. So as example, the commissioner that serves as a board member of a grantee would have a personal conflict requiring them to recuse themselves from decisions affecting that grantee. Similarly, a commissioner with a past relationship with a grantee would likely have a personal conflict. And so Business Professions Code section 6036D mandates the disclosure of the conflict and recusal if a commissioner has a personal financial conflict with regard to a decision. But in practice, what that means essentially is that the commissioner with a conflict should abstain from giving a decision or a portion of a decision due to a financial or personal conflict. What that means is usually prior to voting or discussion on an issue, it's enough to simply note that you have a conflict and will not be participating in the discussion. There's no need to elaborate on the nature of the conflict. So broadly speaking, if you have any concerns about whether you have a personal financial conflict, you'll feel free to reach out to myself or Brady, who is sort of our head conflicts person in the Office of General Counsel. The other conflict of interest issue you should know about is our conflict of interest code. It's adopted by the Board of Trustees every year, as there are often changes to the Political Reform Act and the Fair Political Practice Commission regulations. However, the bulk of our conflict of interest policy, to the extent it applies to commissioners, concerns the annual Form 700 reporting. Commissioners are subject to the lowest reporting level, and therefore you only typically have to report financial interests that would be a conflict. Again, the financial conflicts that are most likely to arise in this situation is if it's of a spouse with an employee or contractor of a grantee. The conflict of interest code also specifies that commissioners cannot accept honoraria or gifts totaling over $500 in a calendar year from a specific grantee or potential grantee. As I referenced earlier, these financial conflicts are unlikely because by statute, the commissioners cannot serve as a consultant or employee of a grantee. Okay. So what does our conflict of interest rules not cover? They say they can serve on the board of directors of grantees. They must serve on the board of nonprofits operating in areas that overlap the commission's work. And members of commissioners' households may be employed by grantees or potential grantees, though often that would be considered a financial conflict and recusal would be required. So that's what I was going to mention about our conflict of interest policy. And then I also want to do a little brief overview about Bag-the-Keen. So since 2016, the State Bar has been subject to Bag-the-Keen. Some of you may have heard of the Brown Act, which applies to local governments. Bag-the-Keen is the state version. It provides rules on the notice required for public meetings and prohibits members of public boards, such as the commission, from doing business outside of public meetings. And so what entities are covered by it? Generally, the State Bar and its sub-entities are subject to Bag-the-Keen if the entity exercises authority delegated to it by the board. The Legal Services Trust Fund exercises its authority by statute, and its committees are exercising its authority by delegation. So the Legal Services Trust Fund Commission and its sub-entities are subject to Bag-the-Keen. So the purpose is pretty simple. The goal is so that public business and the decision-making process is made out in the open, and that the public has an opportunity with notice to participate. So under Bag-the-Keen, what is a meeting? Under the government code, if more than half of the committee members are together, whether that's in person or on Zoom or over the phone, and discussing the subject matter of the sort of jurisdiction of the commission, then the requirements of Bag-the-Keen apply. A meeting doesn't have to occur in one place. It can be a series of communications, and as I said, it could be by Zoom or phone call. Also, materials distributed at the meeting have to be made publicly available. So one thing I want to flag is that due to COVID, there were specific requirements for teleconference meetings requiring the disclosure of the location of the meeting that were suspended because of COVID, that will be coming back into effect on July 1st of 2023 for 6 months. There is legislation going through the legislature right now to revert to our prior policies where these requirements were not in place, but absent emergency legislation, that's something that will be required going forward. Primarily that teleconference meetings, at least one member of the body must be physically present at the location specified in the notice, and each call and location must be open to the public.
And this is going to be really important for us because we have a slew of meetings starting in July. So if you want to participate from a location, we have to notice it, which means you need to respond to Kim's email. So we have your notice location. Otherwise, you're not going to be able to participate as a commissioner.
Right.
So and I just want to sort of reiterate, the awkwardness of that is that if you are going to participate from home, that will be in the public record. And the public has to be able to access your home in order for you to be in compliance, which is why I think we're going to see a drive toward more people appearing in person or appearing at work. But if you are going to have it at work, then there's got to be a place for the public to actually attend, which raises a separate issue, which is that it has to be accessible. So if you don't have an accessible building, that's something to keep in mind.
We can offer up a WeWork location. So if you would like to participate maybe closer to home and can't come to the State Bar office because the next meeting will be in person, both San Francisco and Los Angeles again, then we can cover the cost of the WeWork location. But we'll need to coordinate with you more in advance for that in order for you to get the proper rework, the paperwork, the reimbursement, and for us to notice that WeWork location.
Okay, thank you for that. I think so it covers what was just said. Oh yeah, so Bagley King also has public comment requirements. The state body shall provide an opportunity for members of the public to directly address the body on open session agenda items before or during the consideration of the time of the item, which means that it's at the discretion of the chair to adopt reasonable regulations, whether, for example, to accept public comment at the beginning of a meeting or at the consideration of each item. So it's also important to keep in mind that communications over social media can become a meeting subject to Bagley Keene if over half of the commission is discussing something that is of the matter of the commission. So while we encourage members of the commission to feel free to share news, we could ask you to be careful about about commenting and liking posts amongst each other, because there's a chance that could become a Bagley Keene meeting subject to notice and the other requirements of the Act. So for example, yeah, if a member posts a meeting on Facebook page and other members begin to comment, that could become a Bagley Keene meeting. So best practice is to use social media to communicate with others, but not with other commission members. So this is likely rare, but just so you're aware, the remedies of enforcement for failing to comply with Bagley Keene is that a decision made by the commission could be overturned, and the penalties can potentially escalate up to a civil action and even criminal penalties. A willful violation, for example, can be a misdemeanor, but I would say just in practice, this is unlikely or at least rare, and there are certain defenses that can be asserted. And so I mentioned the California Public Records Act because under the Bagley Keene, our meeting materials have to be made public. So it's just something to be aware of. And so the California Public Records Act creates a presumptive right of access to any record created or maintained by the state bar that relates in any way to the business of the state. Generally, any person can request access to those records. Right, okay. And as far as what you need to keep in mind in your work for the CPRA is that your communications, text message, email are all potentially disclosable, including those on your personal devices. So to avoid any Bagley Keene issues, we should likely not be communicating about a meeting without at least copying a member of the state bar staff, so that we don't need to ask you to turn over your records, and the record would exist within the state bar files.
Yeah, I can, Raul, can we just pause it for a second? So if
Sure.
you need to communicate with another commissioner, yeah, just copy either myself or if you're dealing with committee work, the committee coordinator for that, because if there's a CPR request, we won't have to roll back to State Bar staff has everything that we need to then respond to that CPR request.
That's right. So yeah, so just some high-level tips. Be careful when emailing about State Bar business, as it could be considered a public record. Avoid conducting conversations about commission business outside of a notice meeting. Keep emails regarding State Bar business separate from your personal emails, and always copy State Bar staff. And then comply with any requests from the State Bar to search for certain emails if you indeed get a CPRA request for those records. And if you have questions or unsure, feel free to reach out and ask.
And it's really, really unlikely, this is just out of abundance of caution, in my 8.5 years, there's never been a CPR request related to the commissioner. We do get them for grantees though, but not for commissioners.
All right, and that's it. So if there's any questions, you can feel free to email me or reach out to Brady. I've listed our emails and phone numbers, and I can circulate this if necessary. Okay.
Any questions? Okay, just a couple of quick comments for new commissioners in particular. One on the conflict portion of the presentation, and thanks a lot, Raul. That was helpful orientation. You'll see it most frequently, and this is sort of where to be aware of it, on our votes on various grants where we have relationships with the grantees. So you'll often hear or see a list circulated and people announcing an existing relationship with a particular grantee. So that's sort of where you'll see it most regularly and where to be on the lookout for it. The good news is that I think a lot of us have relationships with the grantee and the grantee community. So that, I think, enriches the work and makes it better, but it does mean that you do have to be mindful when the votes occur to recuse yourself accordingly. And then in terms of Bagley-Keene, where you see it sort of most regularly is the size of the working groups that we set up will sometimes be limited in order to avoid, creating a situation where Bagley-Keene will kick in unnecessarily. So just, for example, we may have a 2-person working group as opposed to a 3-person working group, or we might not set up a committee, etc. Most importantly on Bagley-Keene, and this is just something to be mindful of because these meetings are all recorded and because we're making grant decisions in a very public space, that's quite unusual. And I'm not really aware of any other grant making deliberations that are quite so public, but it's something to sort of be mindful of when you're discussing the merits of applications or the merits of particular grant applicants, just to maintain, I'll say this goes without saying, but I'll say it anyway, maintain, your professionalism and your general understanding that what you're saying is being recorded and for posterity. So that's where you see those two things most regularly, and that's something to sort of keep in mind. Let's go backward on the agenda real quick just to approve the minutes from the March meeting. So I will entertain a motion to approve those minutes.
This is Jeff, so move.
With your indulgence, Jeff, and then Bonifay, I will second. Thank you. Let's vote.
I'll do roll call, and then for the commissioners that were not in attendance at the last meeting, we've been advised by OGC that you may vote yes in confidence of your colleague, your fellow commissioner. Agwagi?
Yes.
Ball?
Yes.
Whitemaster? Blakemore?
Yes.
Bocelli?
Yes.
Campbell?
Yes.
Escobedo? Galkin? Biskin?
Yes.
King?
Yes.
Klein? Judge Klein? Cruz, Lee,
Yes.
Mahoney,
Yes.
Meeker,
Yes.
Milburn. Yes. Morales,
Yes.
Vargas. Alsaroff,
Yes.
Connolly,
Yes.
Schreiber,
Yes.
motion passes.
Okay, thank you all. All right. We have a lengthy and exciting presentation, such as it is, for a big part of what we do here. So I'm going to hand it off to Duan for our IOLTA update.
So Michael and I are going to be co-presenting this agenda item together, and this is probably one of three very important agenda items at today's meeting. Every year at this June commission meeting, the commission will vote to send a recommendation up to the Board of Trustees that's meeting in a few weeks about what the 2024 what the following year's distribution for IOLTA will be. For this year, we're going to be recommending for 2024, and we have a lot of good news because revenue is going up. So Michael and I have a short PowerPoint to present, and there's a lot more details in that memo. So if you need historical background, it's all in that memo. This PowerPoint is really just we're extracting what we think are the most salient and relevant points for you.
Great, thank you. Let me share the presentation with everyone. Just 1 second, and I'll pull that up. Is everybody seeing the presentation?
Yes.
Great.
The
Thank
slide.
you.
Michael, can you advance the slide? Okay, great. So we're gonna go a brief background on kind of the IOLTA statute, the Fed funds rate, what it's been, what our current guidance around our reserve policy is, what the rules committee is doing to kind of revamp the reserve policy, and then we're gonna go into projections and then what the staff recommendation will be. Advance, please. Next slide. Okay. So to start off, as you all know, our interest on lawyer trust account grants, our IOLTA grants, attorneys are required to put into interest-bearing accounts client money that they hold that's nominal and short-term. So banks are required to kind of remit that to the state bar, and the Trust Fund Commission distributes that as legal aid grants. So because they're in interest-bearing accounts, the amount of funding tracks tracks the federal funds rate. So right before the pandemic happened, it was actually a good kind of interest environment for us. We're about 2.5%. Then pandemic happened, it dropped it pretty much overnight, instantaneously to near zero. We were at that near zero kind of interest rate environment for several years. Then the beginning of last year, the Federal Reserve started raising interest rates. They raised interest rates, and Michael, correct me if I'm wrong here, 5 times last year. We ended last year a very high interest rates, and then this year interest rates are continuing to climb. So the Federal Reserve met February 1st. We're at a 4.25 there, and in March we're at 5%. In May we went to 5.25%. They just had a meeting in June, just a few days ago. Interest rates were not raised at that time, so we're at 5.25%. This is double the amount of interest rates that we were at pre-pandemic. The commission, the state bar, has never seen interest rates at this level for IOLTA interest rates, and that's also in combination with the amount of net assets, the amount of what we're holding in total for all IOLTA accounts. Those two drivers are really driving up revenue, and Michael's going to go through projections really closely in the next few slides down the line. So that's where we are in kind of interest rate environment. So today the Trust Fund Commission again is meeting to finalize that recommendation, and then the Board of Trustees is meeting in July. The one thing that's been different the last 2 years is because there's been legislation that was passed that gives the commission more authority. So the Board of Trustees will not overturn your recommendation. They can only overturn a commission recommendation if there's a fiduciary, contractual, or legal conflict. And in this instance, we work on these recommendations alongside both Raul and Brady from the Office of General Counsel. They would flag for us if there is anything that the commission is doing that's like improper. And so they have given us the green light on this recommendation. So we do not anticipate that the board would do anything to modify that. So it's more of a formality when it goes to July. For now, it used to not be that way, but for now moving forward, it's a formality, and then we'll be able to share with programs. And what we've been doing the last few years, that's kind of the advice of the Legal Aid Association of California, is we've actually been sharing projections a little bit more frequently than we had been before. In previous years, we would only share projection. We would only share the final number once it got approved by the Board of Trustees. So they'd only get once a year update from us on IOLTA revenue. What we're doing now is we're sharing regular updates after the commission meeting. We actually have a pre-drafted email that is set to go out that will share what the commission decides, what the revenue projections are, and this really helps our programs kind of plan. Also, given the volatility of IOLTA, this we have heard has been really helpful in budgeting. Michael, next slide, please. Okay, so this is a little background. I'm not going to spend too much time on it because we already mentioned it. The IOLTA statute, which started this whole program, started the Trust Fund Commission, started our program at the State Bar for legal aid funding. We started in the early 80s. It's been amended once in 2008 so that we can collect comparable products from banks. The other thing that I'll note is that in 2019, the commission and the State Bar started what we call Leadership Bank Program, where if banks opt into paying kind of a higher interest rate, then we will put them on the State Bar website. And that has actually, during the pandemic, fended off a larger drop in IOLTA revenue than could have been. So it's a really great program. We are looking to revamp that program now that we're close to 4 years plus in. We think there's a lot of opportunity. There was a presentation at the last commission meeting about how we will be, at some point, be starting a working group to look at things like, and it's going to go through the Bank Grant Committee actually, to look at things like marketing for Leadership Bank Program. Are there other kind of criteria that we want to put as part of being a Leadership Bank Program, such as like social responsibility metrics? So that's all forthcoming. But the Leadership Bank Program has just been really a smashing success for us. Michael, next slide, please. Okay, and then we just also want to note that the bulk of IOLTA grants do come from the IOLTA revenue interest, but there are a couple of other places where we're getting funding from. In some instances, pretty significant. So on the attorney licensing fee bill, there is an opt-out portion of is it $45 now? So $40 of that goes to the Justice Gap Fund for us to administer as part of IOLTA grant, and the other $5 actually also goes to the Trust Fund Commission to administer as summer fellowship. So that those donations, we get anywhere between $7 and $9 million a year. So not an insignificant amount. I'm sorry.
700,000 to 900,000.
Yeah.
Oh, sorry. Yes, so 900,000 for that $5, but for the total though. For the total, it is, yes, sorry. For the total of Justice Gap donation, it is between $7 and $10 million. So it's a large amount. We counted in as part of projection, and then there's some smaller instances, grant repayment. And I used to actually say in this presentation, invested income used to be not that much, but because the interest rates are going up so high, we've been working more closely with our Office of Finance to put into more aggressive but safe products. So like for this year, you're going to see Michael go through this. Our investment vehicle alone itself is going to garner about $2 million, and it used to be like 100,000 or 150,000. So it's a fairly significant number.
It's incredible.
Yeah, it's an incredible number. Next slide. Okay. So this is the current kind of guidance, and we actually in the past the commission has took it more of a policy. There was a 2006 memo that was drafted to the Board of Governors at that time, which is now the Board of Trustees, that recommended a distribution amount that year. It within that memo tucked kind of like guidance that the commission used to take as a reserve policy, and the guidance was, it gave kind of instructions of when there is decreasing revenue, the commission should leave a cash on hand reserve of between 30 and 75% from the prior year's reserve, and then when revenue is going up like they are now, it provides for a 4-step process. So the Rules Committee has a working group that's working to revise the IOLTA reserve policy. And in looking more closely at that policy, we realized that actually the commission was never really subject to that policy. The motion that was voted was purely a motion to approve the distribution that year. So it's been guidance. So we haven't done anything that we could not do, but we are not subject to that 2006 memo to say. So one of the recommendations that's coming out from that particular IOLTA working group reserve policy is to adopt some of the principles that they will be recommending, and the Rules Committee has actually seen this earlier this week, to adopt some of those principles when you're thinking about the distribution for 2024. Michael, next slide. Okay, and Michael and I will do the slide together. So these, and Erica's sitting next to me. So Erica's one of the main architects behind this, the new kind of working group proposal. So she can help me out. So these are kind of like the principles of the new kind of guidance. So previously, with the former guidance, staff was asked to project out close to 2 years, really 20 months out, in order for this commission to make a determination of what the next year's distribution would be. So we would always project for the remainder of the year and all of next year. The new recommendation now is to just have staff project out through the year, and then we would take what that money is, the amount of money is at the end of the year, and that's what we're calling net assets. And that would be the basis for the distribution the following year. And then the commission would then be allowed to hold back what we're calling a reserve to deal with like fluctuations in IOLTA. And that working group is also proposing an allowable $25 million maximum account for that. And then that can also rise with like inflation or other kind of instances. And also the working group's also recommending like the possibility of a multi-year budgeting, which we actually will be recommending for this year's distribution. Anthony, did I miss anything about that? Okay.
Can you, just one request, can you explain what you mean by multi-year budgeting?
Yes. So usually, and I should say always, not usually, the IOLTA statute requires the commission to distribute IOLTA grants annually. And the commission has always interpreted that, staff and the commission have always interpreted that to mean that programs have 1 year to spend down the grant. We took a closer look at the statute, and that Brady thought that like we're not really subject to that. So the commission can actually, you still have to do a yearly distribution, but you can choose to allow programs to spend it over 2 years, 3 years. The recommendation this year is because, and you'll see soon, the distribution is so large to allow programs to spend it over 2 years. So you're providing a 2-year grant. Next year, though, you will also be distributing another cycle of IOLTA funding. Okay.
Yeah, and just, we have some nonprofit veterans on the commission. So I think it might be helpful at some point for you to sort of weigh in and explain why that's useful. I would only note that there's a simplicity in, year out, and an increased administrative cost or burden to track 2-year grants that continue to roll out, where you've got sort of an overlapping cycle of money going out. So anyway, we'll come a little bit more to that, but I just wanted to flag that for everybody.
So with that, I'm going to hand it over to Michael to go over the numbers.
You don't. So just a quick recap of the Fed funds rate and the excuse me, the distributions historically look like. So just wanted to sort of focus in on more particularly the last year and this year. So at the end of 2022, the Fed funds rate was at 4.5%. We had $63.7 million of IOLTA revenue, including the donations that we spoke about. This was 103.5% change over the prior year. The grant distributions in 2022 were $35.5 million. This was also a good bump from the prior year of 24 million, so 47.9% increase. When we roll into 2023, the Fed funds rates that we're projecting and anticipating that will be at the end of the year is at 5.25%, and the total IOLTA revenue being projected through 2023 is $131.3 million. And just as a little bit of a context, this is 106% of the revenue from the prior year. So because of high interest rates and high depository balances, these two significant drivers are contributing to what the revenue picture looks like right now. And so for 2023, we are distributing $50.7 million in IOLTA grants. This is, I think, the second highest year. The highest year was in 2020, where we sent out 55.3 million. But you know, at 50.7 million, it's still a very large distribution, and this is 42.8%. When we look back a year ago, just from a grant distribution standpoint. So I think all in all, for 2024, as we sort of see, it will be another sort of increase because of where the revenue is pointing. This next chart is just a good point of reference, tracks and dots in a graph where the distribution has sort of ran. And so, you know, for the most part, up until 2018, it's been fairly flat between the $13 to $15 million level. It's been trending upwards more recently. And, you know, in 2021, right at the onset of the pandemic, we had a really big dip, but it's been creeping back up since then because of, again, rising interest rates. And then secondly, the depository balances has gradually increased overall. And so contributing to the amount of revenue that we're seeing. This is just a quick recap comparison of what the Legal Services Trust Fund and the Board of Trustees approved in last year's projections. This might be a chart that maybe have previewed and shown to the group prior, but just really quickly, just a comparison between the 2022 year-to-date total revenues from the prior projection. We were projecting $32.9 million almost, and actual activity for 22 saw 63.7 million. So overall, we had a $30.8 million increase between year-end results versus what was projected. So that's a significant increase, definitely. From an expenditure standpoint, I think we were pretty much on spot. We projected around 38.5 million. Actual activity for 2022 was 38.8 million. So small difference there of $273,000. So we're fairly close in terms of those projections there. And in the end, the ending net assets for the Legal Services Trust Fund, from a projection standpoint, we had $30.9 million projected. We actually ended up with 57.5 million, which had a differential of 26.5 million approximately. And that's 85.5% higher than anticipated. So overall, again, the driver for everything has been interest revenue between the depository balances that's been sort of prevalent, and also the rates that have been increasing actually at a higher and more aggressive pace, I think in 22 than we had anticipated. And so this sort of brings us to the setup for the current revenue projections. So these are the similarities shared across the projection models. Similar to last year, we prepared 3 variables in terms of the projection model: an aggressive, a moderate, and a conservative model. All 3, as a basis starting point, we have remittances already realized for the first quarter of 2023. Remittances at that point, for that point in time, for that first quarter, is already at $34.5 million, approximately. You know, as we mentioned, we are in a period of increasing net IOLTA revenue. You know, the rates have risen a couple of times already this year. We don't anticipate it to fluctuate as greatly for the remainder of the year. I think looking at the few forecast models and tools out there, there's probabilities that we might see one increase potential. There could also be some decreases of rates at the end of the year as well. So we've taken those into consideration, but in general, not the crazy types of swings that we saw in last year. From an investment income standpoint, we are estimating investment income to be much more substantial because of the fact that we're strategically identifying what our cash flow needs are and deliberately setting aside a portion to be invested in secured but higher yielding type assets. So I think currently we've got $55 million invested in treasury bills that has a 90-day maturity time period. That's got a fairly decent yield. I want to say the yield was 5.26% or so. And so for the remainder of the year, I think just on the anticipation of what that might look like, it'll be around $2 million just by doing that activity alone. And so what's really great about that is any investment income that is garnered through that activity is coming back straight to the program. Voluntary donations through the fee statements and justice gap donations will slightly decrease a little bit for the model compared to last year. And then the total amounts on deposits in banks, we're anticipating that for all bank rate types. So there's banks that pay on a comparable rate. There's banks that pay ECR and leadership bank rates, which are in themselves tied to the Fed funds rate. We do anticipate that there will be a drop, and we've utilized that in each one of the 3 models, drops in depository balances. It is a bit of an anomaly in talking and working with our consultants that you know, other states have seen drops over the last you know, 6 to 8 months as banks are looking to control costs. But California really hasn't really seen that, which is a bit of a head scratcher there. And then last assumption that's prevalent across all 3 projection models is a $25 million deposit or restricted reserve balance at the end of 2023.
And that's the recommendation that's coming
Yes.
from the working group that staff agrees with. If you were to accept the guidance of that working group, is to put aside that 25, just because we're in such a good revenue environment, that we think putting aside 25 million is probably the prudent thing to do.
Are you taking some questions now?
Oh, we're happy to.
Yeah, I don't know, Michael.
We can definitely.
Yeah,
We're
okay.
we're happy to take questions now.
Yeah, feel free.
Complete that.
Cool. Why don't you continue then, Michael?
Okay, no problem. And so I wanted to go through each one of the scenarios for everyone. We'll start from the aggressive and work our way to the conservative. On the aggressive model, for 2023, just on IOLTA interest alone, that model is projecting interest revenue of 135.9 million. When we incorporate the other revenue streams, total revenue for the program is at 146.9 million. And once we deduct the expenditures and the transfers to the restricted fund balance of 25 million, we will have available 125.23 million in ending net assets for funding. And in this particular model, we are anticipating that the Fed funds rate increases one more time, sometime in August, based off of some of the probabilities out there, to 5.5%, and then it would hold for the remainder of the year in 23. It also anticipates a 25% reduction in depository balances. In the moderate scenario, we're forecasting interest revenue for IOLTA for the 2023 cycle at 120 million or so. Total revenue, including the other revenue streams, is 131.27 million. When we deduct the expenditures and the transfer to the reserve, it gives us 109.58 million in net ending assets for the purpose of distribution funding. In this particular model, we're anticipating the Fed funds rate sort of remain stable for the rest of the year. So it's at 5.25%. We're not touching that for this model. This model incorporates a 35% reduction in depository balances as well. In the last scenario, the conservative one, it is still projecting interest revenue for IOLTA through the rest of the year of 106.12 million, with total revenue being 116.92 and 95.23 million in net assets for the purpose of distribution funding. And that's after you deduct administration expenses and the transfer to the reserve. This model in particular anticipates two decreases to the Fed funds rates of 0.25% each, once in November and another time in December. It also incorporates a 45% reduction in depository balances. You see Eric's got a hand up. Do we take questions now?
Yeah, it's up to you. I don't know if there's an additional slide or.
Let me put the numbers up, and then I think after that would be a good junction for a pause.
And then we're recommending just the moderate, the one in the middle.
Yes. So on this next slide, this is how all the details break down. What's highlighted in blue is the moderate projection of scenario B. And, you know, what we're anticipating is based off of scenario B, we will be able to distribute, and what's being recommended for the 2024 IOLTA grant distribution is the total of the ending net assets of $575,900. And within that particular model, we're also putting away $25 million in the restricted reserve balance. And so I think that's probably a good stopping point, because that is the bulk of the presentation. But I know it's a lot to go through and digest at once, so would be happy to go through any questions at this point.
So just to clarify, Michael, you're suggesting that 109 million be issued?
Yes.
Grants. Just so, okay, thank you.
Bonafide, then Eric.
You know, some of us were here during the, you know, the the downfall of civilization. And, you know, I came on when Jeff Ball was chair, and he was trying to hold it all together with the commission at the time and the staff at the time. The next, and did a brilliant job. And then the next time was when, you know, Christian, some of us were here, again, we had another kind of downturn. Every time we've had a financial downturn, we have been more on the moderate side, always looking to see how we could get the money out to the community, to the organizations, as quickly as possible, because if ever they needed it then. This is obviously not a, I think it has to do with those of us who are old timers here at the commission, that we're going to be leaving the commission, Christian, in such a, this has to be because of our amazing decision.
I didn't want to take credit, but thank you for giving it to me. Yeah.
I mean, what else could it be? But I want to caution us from that historic perspective. Definitely getting the funds out, the community needs it. And balancing it with, there is a deficit currently at the state level. There will be a day that we will be back at, lower interest rates. So, I appreciate the 25 million. I guess what I'm looking at is, should we earmark more and set more than 25 aside, given that the grantees are having a hard time, getting this money out and are going to be holding on to it. So there's obviously this constant balance, and it's important to maintain that balance. But I am at this point thinking we may want to be even more conservative, given that we just don't know what we don't know in terms of these two, that the graph that Michael just showed us, that, pretty much we were staying at the 11 million. I mean, I remember, and Jeff and Christian would probably remember, we were in single digits. we weren't in this flush state. So just a voice of warning to all of us in terms of, we are in a good position. How can we even be more mindful of putting more money aside in preparation for a potential of 2008, 9, 10, and there are a lot of conversations that are going in that direction. So that's all I have, and I see Jeff.
Can I respond to that really quickly? Because that was definitely discussed very heavily amongst the staff as well as in the working group. I mean, personally, I think the staff recommendation initially was to have that reserve be closer to maybe $60 or $70 million and give programs a meaningful bump, right? And still get them to $70, $80 million, but hold back a lot more. The working group did convince us, and I now agree that that's really not a viable option politically. The commission doesn't usually hold on upwards even $25 million. So hold into the bank $50 or $60 million might not have a good look in a year with a budget deficit. We're not doing well with the state budget. That might put us a target on EF, potentially. So that was and that's why we came up with letting programs spend it over 2 years as giving that flexibility instead of spending at $109 million in 1 year, which we don't know is even possible as a community.
Eric, then Jeff.
Yeah, I'll just be short. I hear what Juan is saying, but I have to say I kind of agree with Bonifay's reaction that this is a staggering amount of money, and in many organizations we've noted have had trouble spending the allocations that they've been given. Not to mention this incredibly increased number here. 25 million, I guess, is a 10-year average of what we have reserved, I think. That average is heavily weighted by the early years that were low. And I'll just say that I agree with Bonifay's reaction. I think we ought to consider increasing the reserve.
Jeff?
Well, first of all, in representing the firms that actually pay this interest, you're welcome. But and of course I say that all in jest, but first of all, I want to compliment staff. They have done an excellent job in how they've approached this, in laying out the data, and I think making it in a very clear position that we can all understand. The conflict that we have to weigh, that Bonifay laid out very eloquently, I agree with. There will always be economic cycles, but I think ultimately, at the end of the day, we want to see this money go to the best use possible. We know that the need is out there. We need to really push these organizations to get the assistance out. And I strongly support the idea of the multi-year budgeting. I do agree that we could look to a larger reserve. We have this balance of wanting to get the money out, but we want to make sure that it's being used. And then, of course, also offset with trying to smooth the revenue sources as best we can. And I think a lot of the efforts that we had in the past were really looking at as best we can to smooth it out. And we can do that more effectively with a larger reserve. So I do support the idea of having a larger reserve, perhaps moving to more of the column C area for funding. And I will just remind everybody, having said that, that this is all based on a forecast that looks at a substantial drop in the deposits. That's based on legal activity. That's the amount that is being held on retainer, which is based on legal activity. So there is quite a bit of conservatism in the projection already.
Yeah.
Catherine, then Will, then Joe.
So thank you. I was a member of the working group and just want to acknowledge all the work that the staff did on lots of different scenarios. I'm going to, I appreciate what Bonifay and others have said about trying to use this as an opportunity. And I think we had that in mind when we came up with the 25 million with the two other possibilities. So it can be increased as a result of an inflationary factor in as time goes on, and also allowing programs to budget the money. And my worry is that because of the state deficit, that increasing a reserve beyond 25 million sends a signal to the legislature, who pays attention to what's happening with the Trust Fund Commission, that there isn't either a need for an equal access fund, or in a state budget climate that will have reductions, that it would make sense to reduce the equal access amount. So I think there has to be some balancing of sort of what are the implications of a larger reserve on funding that we also want to get and be able to maintain from the state.
Will?
Thank you. I have a clarifying question. So our distribution in 2021 was 23, almost 24 million. In 2022, it was 35 million. And under the column B, the distribution would be 109 million. But it could be split in half, so 54 million-ish. So it's still a sizable increase. Is my interpretation correct? My understanding?
Yeah, I think that's probably a way you can look at it is, because the distribution is 109 million, with us deliberately combining that with a multi-year budget approach, effectively they can spread that 109 over 2 years, or 50+ million per year, which is around this year's 2023's single year distribution level, right? So, I think when we started looking at the amount of interest revenue coming in, we understood that without looking at a budgeting approach that was going to be flexible, we were going to set ourselves up for a very clear possibility of a large amount of carryover requests coming in, because there was no way that organizations were going to be able to spend that, this type of money in a year. So I think that really contributed to looking at it from a multi-year approach, so that it feels more doable for organizations. And the fact that they know they have 2 years to spend it, they're better able to plan to spend it over that period of time versus worrying about, can I do it over 1 year? And if I can't do it over 1 year, will I be able to get the carryover request? With this sort of deliberate approach of letting them do it over 24 months, it takes that sort of burden and anxiety away from them, which we're hopeful will be helpful to them.
But they will be getting another distribution, just to be clear, so.
Right.
Kind of
Right.
the way that you just described, Will, but this time next year, the commission will make another large distribution.
Yeah,
So it will be stacked.
it's gonna look
But
like a
it's
snake that just swallowed a horse.
And
So, but it depends on the financial climate.
Right, exactly.
Things could drop.
Exactly. So we're at the end of June now. We're not anticipating like large swings in the interest rate, but there is sort of significant probabilities at the end of 23, starting at the end of 23, throughout 24 and 25, that the interest rates that we've seen climb so quickly over the last year or so, all of a sudden start to swing backwards, right? And then, so in 2024, we may not be at that 5%, 5.5% mark. We might be at 3.75%, right? So if you do the math, all of a sudden, it's tens of millions of dollars all of a sudden being lopped off just on interest revenue because the rates are going backwards, right? So we know this is probably to a degree an anomaly of sorts. It's temporary. It won't last more than maybe 1 year and a half. But that is a distinct possibility. And so, next year at this point in time, if the rates all of a sudden swing the other way around, we may not have as much to be able to distribute from an interest revenue standpoint. But I think our act of trying to put away the $25 million and doing that sort of ensures there's a safety net mechanism that we put in place that we've never had the ability, or we've never put in place. We will not utilize the $25 million unless we need to. So, that's a mechanism. There's going to be a mechanism there for the commission to electively start to utilize those that reserve amount when time calls for it. But at least it'll be there. So I think we're trying to, like what everyone is saying, we're trying to balance out the needs of I think all the suggestions that everyone has, sending money out to the organizations, putting away money for a rainy day, and specifically not utilizing that until we need to, and then also giving flexibility in terms of how organizations can spend the money when we know it's a large amount.
Joe, Judge Seligman, and then I'm going to invite Lauren to get in the queue there, if you would, because I think it'd be helpful to get some perspective from LAC. Go ahead, Joe.
All right, thank you. So just by way of disclosure, I went to law school because I didn't want to have to look at sheets of paper with as many numbers as I'm looking at right now. And I think actually Michael may have just answered my question. When I came on the commission, I guess about 18 months ago, we were in an environment where you could get like 0.5% interest. And that has changed, obviously. And now there are banks offering online accounts of 4.5%, 5%. And I think I wanted to make sure that we were taking full advantage of that. Michael's comment of a minute ago suggested that we are. So maybe he's answered my question. If I could just ask him to confirm that I heard him right.
Definitely. We've definitely strategically have gone through that process of looking at our sort of cash flow needs every sort of quarter or so, and then based off of that analysis, we've done it 2 times already. On both times, we're able to come away knowing that we could put aside $55 million. We did it once earlier this year in late March. I think the yield on that 90-day investment was close to 5%. I think it was 4.86 or something at that point in time. We just recently went through that analysis again, put away another $55 million, and the yield on that was over 5.5%. So we're deliberately going through that process of making sure we're just not leaving it in the checking account. Even though the checking account is paying a decent rate right now, we're getting a little bit higher return by specifically working with our CFO and putting into investment vehicles that have a higher return.
Great. Well, thank you for confirming, and you're doing better than I am. So that's great. Thank you.
Jed?
Yes, I just want to state what I think the implications of the multi-year budgeting aspect is, which might help assuage some of the concerns we have. In a way, the multi-year process allows the trust fund recipients to create a reserve account themselves. We don't anticipate most of them are going to be able to spend the money this year. A lot of them are going to have money left over next year. So if there is a precipitous drop in our income, that's going to be partly cushioned by the fact that they've put that money aside. And I would say doing it that way is politically much less vulnerable, perhaps, than if we had that huge reserve ourselves. So another aspect of it also is, I presume we're going to be able to monitor at the end of this year how many people are keeping those reserves. And in making our grant decisions next year, one factor that will inform it is how much money they have left over. So we have the ability to take that into account also. So I think the multi-year budgeting, which is a change in prior practice, is of very substantial significance, particularly in good times. And having been here in the bad times, and the good times, and the bad times, and the good times again, this budgeting change, allowing them to do it over several years, is a very significant change, I think.
Lauren?
Yeah, I definitely agree with Judge Seligman on this. You know, Selena served in the IOLTA reserves working group, and we talked extensively about these issues with programs, and we support staff's recommendation here. No matter how you look at it, this is going to be a lot of money for programs to spend, and that will be hard for them. But I would really underscore Catherine's point that it makes our advocacy for state funding difficult if we have too much money in a state bar reserve. Legislators will notice that. They will think that more money isn't needed, and that can have really reverberating effects in years to come as we try to advocate for more funding. What Judge Seligman pointed out, I think, is very true. This multi-year budgeting kind of lets us do the best of both worlds. We're giving programs a lot of money, but by giving them the ability to spend it over a couple of years, they have a lot more comfort that they're going to be able to make that work. And then we don't suffer the political consequences of having too large of a reserve sitting there, making us vulnerable to people in the legislature thinking that we don't need any more funding and that there isn't any more need.
So I want to, not seeing any other hands up, I'll take the privilege here. So a couple things. One that I haven't heard mentioned. One is that the extent of a reserve is typically tied to the amount of revenue and money that's going out. So you don't need a $10 million reserve for an organization that has $1 million going out. So I guess I see 25 million, and I would like to just confirm this as being a number that isn't really set in stone for 3 years from now. It's a number that we would be able to use to backfill a precipitous drop in revenue to sort of flatten the curve for organizations. Which could mean that instead of having 25 million in 2027, we have a $10 million reserve or a $12 million reserve or a $15 million reserve, which is of course appropriate if we're going back to the days of $15 million annual numbers. So I think that's one point I hadn't heard really made. The second thing is a little bit of a process point. And it's underscored by Bonifay's comments, which resonate. I'll just share my own reflex, which was to be aggressive, which was like the opposite of Bonifay's, because I see this money sitting there and I think that this is really an infrastructure building time for organizations. To tie in a bigger picture discussion that we've been having at many other prior meetings, you know, the crisis in the legal aid community really is recruitment and retention. And this is, you know, an old song. And so I know I'm not breaking news here. But one of the things that has long been reported is that these organizations are reluctant to hire lest there be a drop in funding that suddenly puts them in the position of laying off staff, and they don't want to do that. This to me feels like a place where we're going to see IOLTA money, I hope, used to make staff and careers in public interest and nonprofit legal aid work more sustainable in the long term, as well as sort of more plentiful. And so, you know, we don't really have control as a commission as to what organizations do with that, but I think this transparency with organizations through the process will hopefully encourage them to actually build out some infrastructure. You know, I would just note, and I'm sure this is something that will resonate with anybody who's working at a firm, rent is typically a huge line item for an organization, and the need for rent is in a very weird flux at the moment as people either work hybrid situations or leave physical places altogether. And I'm not really sure where that goes, but IOLTA money can be used for that. And that's the flexibility of IOLTA funding is one of its most important attributes. So circling back to this idea that I was thinking aggressiveness and Bonifay was thinking conservatism, I guess where that leaves me is that I don't really know what's right. I don't know that I'm right. I wouldn't sit here and say I am right, and I wouldn't say that Bonifay's position is incorrect. Because we're really talking about an unknowable, which is what the future holds. I tend not to really like to be off in revenue projections by 86%. That feels uncomfortable to me, but I get it. You know, there are many unpredictable parts of the last 12 months, and I am not casting aspersions on our projection models or anything like that. Process-wise, I guess where I'm left is that the staff recommendation seems to have been arrived at with some very careful deliberation. It doesn't really tie us to a future that will lack discretion because we will be able to make adjustments next year, et cetera. They've spent time thinking about it. Process-wise, this is often how the commission works, where people are assigned to a working group or a committee and come back to the full commission with a recommendation. So it's helpful to hear from Lauren and from members of the working group on that point as well. I do think I want to express one concern, which is the snake comment I made earlier, and that is, you know, if there's $50 million going to be basically given out for this year, 55, and an additional, I'll call it conservatively 35 to 50 next year, that means that they're going to have an $80 million horse to digest here 2 years from now. And the organizations kind of need to know, like, they got to get working on that, because that's going to be a big number. Even if they have 2 years to spend it, 12 months from now, they're going to have to start really getting that money out the door. unless they're going to coming back to us with carryover requests. So I am a little bit worried about that. And Lauren, I don't know if the organizations are ready to ramp up, but I hope they are. So that's it from me. Will, another comment or question?
Yes, you started to bring it up, the budget modifications and carryovers. I was on the why don't we make the reserve 40 million train, but I think the multi-year budgeting helps accomplish our ultimate goal of smoothing out the budgets and giving them an idea, especially because this time next year, they can see what our next year's allocation is going to be and submit a budget modification request immediately to either cut or increase their spending based on what they see coming from this commission. So I think that really helps. But was there thought given into how we will handle carryovers at the end of this period?
I mean, we do have a policy in place in terms of what the numbers are that staff can approve and what will come back to the commission. I think you're right to anticipate and be curious about what we can expect. It's, you know, just for the new commissioners, historically, we've been pretty forgiving with organizations that make carryover requests. So I don't see any reason why we would depart from that. But of course, you know, massive carryover requests, which I hope we don't see, might raise, you know, entirely new concerns. So I think we have an infrastructure in place to deal with them in terms of numbers.
Christian, I have
Yeah.
a follow-up to that, similar to Will's question, and kind of loops in your more aggressive thinking around, you know, infrastructure building. Is there a reason why we chose 2 years and not 3?
That's a really good question. So a couple years ago, we got that one-time increase for EEF. In the legislation itself, it allowed for an encumbrance period that was longer than typical, which was 2 years. And so we modeled it after that EEF, and then it was different though. That was like a pre-approved carryover. What we're suggesting here is a 2-year grant, but that's what we modeled. But no, you're right, that there is no reason why we couldn't consider 3 or 4 years. But I haven't. But my question to OGC formally was just 2 years. I don't think the analysis would actually change for 3 or 4 years, but that is not something I have ran by OGC.
Because then, I mean, listen, I ran one of these, right? So I wouldn't feel comfortable hiring out, thinking I'm only going to be able to have these folks for 2 years. But if I know that I have a base in place for potentially 3 or 4 years, that opens my mind to wanting to expand the staff pool.
Yes.
Right?
No, you make a good point, and you know, actually, the rules
Is this your
committee.
idea?
No, it was an echo of yesterday. We had a the other day, we had a rules committee meeting and Patience and Catherine sort of both raised this particular point because we're trying to, with Will and Jim, I'm on a working group on the carryovers and budget modifications. And one of the things that Patience pointed out and Catherine did as well is if you have a lot of money, having at least for some budget items, if not all, having multi-year budgeting abilities is something that would be beneficial. We then scrapped our proposed rule and are gonna go back to the drawing board to try to figure that out because there's logistics issues, right? 'Cause we take a 1-year grant and we turn it into essentially a 4-year grant, right? But it makes sense to me that when we are flush, the commission ought to be nimble.
And it could be just in instances like this, like we did special modifications for during COVID, correct? So there are these times that we take these special recommendations into place, and I'm just thinking, you know, I'm concerned that they're going to be able to you know, and LAC can weigh in on this, but I'm concerned they're gonna come back, they're going to ask for carryovers. So, you know, why produce more work for them, more work for the staff? We know that already. The signals are clear. Maybe it's a horse, maybe it's a dog, maybe it's a cow, maybe it's an elephant, I don't know. But it's something, and so why not support the organizations now and build in the potential retention and or attraction, right, of more in this field. So, you know, and I appreciate what the working group has already done, but this is, you know, now additional minds.
So I would propose another way of like building on that, another way of looking at the role of this body. The message doesn't make it, I mean, Christian, when you said this is an infrastructure building time, that's a radical idea for an ED or CEO of a program, a legal aid program. That we could take IOLTA money and use it to build infrastructure. I think this body has the opportunity to send a message to the field programs. This is an unusual year. Use this to raise salaries, use it to build your workforce, and use it like, I had a union. I couldn't just willy-nilly give people extra money, dang. So there, it was, so it was, that message from this commission can be very powerful, and I think the message needs to get sent as opposed to, because that is a really different relationship between the commission and the program from, we want these deliverables from you. We want to know, it's an acknowledgement that in order to serve the clients, you need to build a program. And so it's time to do that. People need to hear that, the programs need to hear that from this commission.
And if I could just complete my thought on that, thank you for what you just shared, because it links to what you're speaking to, which is we're concerned that we want to get the money out. And there's so much need out there. So if they have additional hands, resources, then they can deploy the activity and the mission. But we can't ever not have those deliverables. That we're an oversight committee, oversight body, but it supports the aims, I think, in a variety of ways.
Well, this is a complex environment. I mean, as I share with the rules folks, my lawyers were getting paid 23% less than other lawyers in Fresno that weren't not in big firms, but that were working for the public defender's office or the county council. So that kind of, that is not a recipe for building a strong workforce that's got esprit de corps and that plans to make a career out of legal aid. You can't do that. So we recognize, I was okay with my lawyers paying a passion tax. I mean, this is, you go to legal aid, you don't expect to get paid like you were Morrison Force or whatever. That's okay. But it shouldn't be 23%.
Is that what it was called, a passion tax?
Well, that's what I called it. But I don't know that there's a word for it, but there's a sacrifice you make when you go to legal aid, because hopefully you're not going to make a lot of money, because that would be delusional for one thing. But on the other hand, it's also not what you're there for. And so that's okay, but it shouldn't be that big a gap. So how can this commission be thinking in terms of sending that message? Because if you want to get things done cheaply, then you can just have 1,000 paralegals, and you have more deliverables, sort of.
But I'll say, and then Jim and Lauren's hands are up. I think, from my time on this commission, we have always sent the message that we are in partnership with and working with the organizations that we fund. But I want to make sure that Jim.
Yeah.
But
Go ahead, Jim.
I hear you.
Two things. Is it a done deal that they're going to be able to spend this money over 2 years? Because that's going to really impact less impact on the problem of carryovers. And two, I want to be cautious about the infrastructure, if this really is a time to be viewing infrastructure building, because it's one thing to maybe increase your office space, which is a one-time or maybe a two-time cost, as opposed to increasing salaries for the long term, which is what are we going to do in 4 years from now when the interest rates are back down to 2%? We've gone through our 25% restricted reserve, and we're back down to where we were for the last 10-year average. I mean, you can't take people's salaries away, right? Once you've raised them.
I think it's more hires rather than salary.
Well,
It could be either, yeah, both. Go ahead, Lauren.
I just wanted to speak briefly to this kind of question of whether organizations are going to be able to spend the money. Just to say that, I can't sit here and promise you that every organization is going to have no problem spending that money over 2 years, because the recruitment and retention crisis is real and it's not going to disappear overnight. One-time injection of money, and that is just a fact. However, this ability to spend money over multiple years is going to help programs immensely. That is the number one request we get from organizations when we're advocating for funding, is that they need more time to spend the money. They need to be able to plan further out. So I think doing things like sharing revenue projections multiple times throughout the year and allowing for 2-year budgeting is really going to help the organizations to plan, whether they are a huge organization that is unionized or a small organization that isn't. I think that's really going to help. And lastly, I just wanted to agree with what Patience said about this commission really sending a message to programs about using this time to raise salaries, about being supportive of their work. I do think that means a lot to programs to feel like State Bar staff is working in partnership with them, and they don't always necessarily get that message. So particularly now when they're going to be working really hard to spend these funds and get as much done as possible and to retain staff, I think knowing that they've got the partnership of the commission is going to be really important.
Catherine?
Thank you. I just wanted to say 2 things. One, there was, I think, a pretty significant bump in other, let's just say around 2019. And one of the things that State Bar that did that was very effective was to say, really do a convening to say, here's the ways that you can use this money flexibly to support your programs. And that was incredibly helpful. I was a director of a very large trust fund and other funded program then. And I think just hearing the ideas about flexibility, et cetera, what was helpful. So I absolutely support that idea. The other thing I think to keep in mind is that among the uncertainties in this environment is what is the impact of some decisions that were made in the debt ceiling agreement that was reached around discretionary domestic spending. And at least one program has reported at a committee meeting that it is possible that LSC programs will experience a 30% reduction because the only place you can take money to reduce the expenditures that were required as part of the debt ceiling agreement is from discretionary domestic spending. So I don't think anybody knows for sure is that going to happen, but those are some of the projections, and it just goes to this uncertainty and the need to give programs the flexibility. So some programs may have to use this to support current staff because they're losing other sources of funds. Other programs may have the opportunity to do some of the investing that we've talked about. So just want to support the approach again, and the 2-year budgeting, and kind of that messaging of from the commission.
I have a question for Juan and Michael. So next year, we would not necessarily have to do a 2-year budget for IOLTA money.
You're not tied. The way the working group principle is, like, you would have the option to opt into a multi-year, but you're not necessarily required to.
Okay, and then a related second question. Is it possible after, so let's say we approve a 2-year budget cycle, and the organizations start to report the likelihood of extensive carryover requests for the end of the period, the end of the 2 years. Could we at that point amend the IOLTA grant to become 3 years for the distribution currently made?
I mean, it could be like a pre-approved carryover. So
Yep.
like we would figure out a way to do it. Whether we call it then a 3-year grant, I'm not sure, but we could figure a way to kind of implement that idea. I don't know exactly what it'd be called. I need to check with the grant agreement OGC, but we could,
Okay.
as a short answer.
So I
Is that-
wonder, I mean, that seems sort of, well, go ahead, you finish your thought.
Well, and then sort of the last question, which is to the extent that next year there is a comparable amount to be given out, we could obviously assume, I mean, my concern here is a process one, which is that we have an opinion from OGC about the 2 years, but we don't have one about 3 years. I don't really want to delay things today. It does seem to me to be, you know, I like the idea of 3 years versus 2. There'd be no reason why an organization couldn't spend it in 2 if they had 3, but I just don't want to really delay things. So,
And we were told by the rules committee, that working group that's working on carryover is to go back to the drawing board and workshop things, because there are a lot of like operational issues that I won't bore you with the details on how we need to build out. We're not set up quite to build out beyond a 1 year. We did it 1 year for EF. That's why we were confident we could do it for IOLTA. I think we can do it for 3 or 4 years, but I have to take it back to the whole team and then check with OGC. So I agree with Chris. I don't think we should delay it. We will have the flexibility. We can get all those things in order to come back to the commission and then say, hey, instead of 2 years, if there's some other number that programs can allow to
And-
spend it down.
And at what point would programs learn that there's probably flexibility at the end of the road here? and
Well,
how
what
much
you-
Flexibility.
So what we do is right after this commission meeting, and Michael and Rocio already started to draft the email. Next week, early next week, we send out, we say, this is what the commission has decided. And then if there are caveats to it, like in this instance, the commission, if you go in this direction, is approving a 2 year, and then we are investigating a possibility of whether you might be able to spend an additional, whatever it is you want us to say. We will send that in that message. Again, so once we have some finality, we'll go back. We do a lot of communication with programs. So depending what you want us to say, that's what we'll say.
And I guess what I would say is, I think the expectation is that the working group on the carryover and budget modification, which I think sort of dovetails with this, the expectation is that we're gonna try and have a framework for the August meeting. So I think the expectation is within the next 3 to 5 months, we would have, we would have worked out the logistics and be able to communicate it, which would be before they would get the distribution.
Right. Right, yeah, but we're aiming for August, but I do want to manage expectations. There are a lot of moving pieces.
Yes.
We certainly have something before November. I don't know if quite August, but that's the aim right now.
well, there
That
is an
makes sense.
administrative.
That's-
And we're
We're not
signaling,
trying to do 3 years.
and we're signaling that
Yes.
currently in this meeting as well,
Yes.
so.
I was just, one last point is just to recognize there is an additional administrative burden
There is.
to
Yeah.
track the grant over 3 years, so
There is.
versus 2, and I just want to acknowledge that. I'm not, it might be possible, but whether it's advisable is.
Well, that's the operational piece that Rocio, it's very complicated because of how our it's built out on our grants management system and how our it's tagged in like our finance team. So that's all Rocio is figuring that out for us.
Yeah,
And we're already anticipating and, in different scenarios, so we'll appreciate.
But we can't do it in like a week. We
Yeah.
need
Right,
to
no,
go
that's
time.
fine.
Yeah.
It's just as the programs get
Yes.
the notification of the dollars, they're also learning, oh, I can begin to think about planning and I'll know more certainly by the end of the year.
And then in terms of the messaging, patients, we have had similar requests from programs, so like, what is the commission, they want a recommendation from you all, right? Not just what is allowable, they want recommendations on what to do with the funding. So we are actually, the staff would like to propose some things, and we would like to bring it back to the commission either August or with something a little bit more concrete, not just they can use it for this, but concrete recommendations.
That's super helpful. The other thing that this does is that over this 3, or like, let's say it's 3, or let's say it's 4, whatever it ends up being, there will still be annual grants.
Yes,
That's
and that's statutory, we can't, that we have
No,
to,
that's
yeah.
fine. What that ends up meaning is that the administrators of the programs can look forward to, okay, I'm gonna put more of this, for example, in salaries, but there'll be another grant next year, even if it's lower. And now, wow, that's a big improvement.
I mean, I want to acknowledge the psychology here, which I think you will agree with, which is it's hard not to have a scarcity mindset. And I get that. And I'm not suggesting that, the tide has turned. financially forever and ever, heretofore. But this is not necessarily a time to hoard. It's a time to use this money to address some of the, principal inequities like a 23% passion tax. So I think we should move toward a vote, but I'm going to have Jeff comment, and then let's take up a vote on this recommendation. But Jeff, go ahead first.
Thank you, Mr. Chair. So I think my focus on this is that I really want to see this money go to work. And we recognize the fact that there is so much need, but what I'm hearing is that it's just too much of a ramp up for our grantees to be able to really effectively put the money to work, even with the grace of a 2-year or potentially 3-year budget cycle, which I very much support. I would point out the fact that the restricted reserve is really, it's based upon what our forecast is in revenue. So there's nothing, when we say 25 million, what we're voting on is the actual funding, not the reserve. So I think recognizing the fact that there is concern about the grantees being able to ramp up so quickly, and the fact that we do need to provide this mechanism for them that will allow them to do multi-year budgeting, I would propose, and I'm going to make a motion, Mr. Chair, that we set our funding for 2023 at 95 million. That will allow time to work out these other aspects. And I think we can do that. It would end up, if we're in the B column on our revenue projection, that's going to put the reserve around 40 million. And it will provide a reserve that we can turn to if, in fact, the projections go, if we end up truly in a recession and rates have to drop, it'll provide that much more reserve to try to help smooth out. I'm putting myself in the position of someone who would be running one of these organizations. And while we do grants on a year-to-year basis, I have to manage over the long term. And I'm sensitive to some of the comments that I've heard about the ramp up. So with that, I am making a motion to set the funding for 2023 at 95 million.
I'll second.
Okay, so we have a motion and a second to adopt proposal C on the screen at the moment. Angie, I saw you had a comment or your hand up.
I wanted to ask Jeff then, if we raise the reserve to the 45,000, what does that do with Catherine and Lauren's comments about what the legislature is likely to do, especially because it's a big reserve and it'd be used for a downturn?
Catherine, Lauren, Jim, quickly.
I was just going to say, I actually heard something different than what Jeff said at the beginning, which is there's a concern about a ramp up period if it's a one-year grant, and that when the time is pushed out to a 2-year grant or either a 3-year grant, while the ramp up in the first year might be slower to bring more staff on or to address salary deficiencies, that by providing that flexibility, you are enabling the programs to then manage their budgets in a much more effective way. And for that reason, I'm not supportive of and for what I've said before, keeping 40 million in reserves.
Lauren, Jim.
I'll be brief. I just would agree with Catherine that I think the multi-year budgeting does make it possible for organizations to find this funding. And I am also just would like to reiterate my concern about having $40 million in reserves and the political implications of that.
Jim.
Just a question. I understand we're voting on column C, but are we also including that as a multi-year spend down? And if so, how many years?
So I think we're going to keep it at 2 years under any circumstances. Jeff, clarify, correct me if I'm wrong. But I think we're not prepared really today do anything other than 2 years.
So it's column C in 2 years.
That's the motion on the table, barring.
No, I'm fine with that, Mr. Chair. I'm looking at the resolution that's on page 11 of the memo, which does not address the 2-year. It was my understanding that that was a separate item.
We checked with Brady, we didn't have, it's tucked into the memo, but he said we didn't need like a resolution to say the 2 years. We didn't do that with EF. If you feel more comfortable, then we can put 2 resolutions and say 2 year in there. It's in the memo, it's not pulled out as a motion.
So I think it's good to have it,
Okay.
if not separate, at least
Sure.
be part of the motion. So
Michael, can you pull it up and drop it into that
Sure.
motion?
Give me a
Judge
second.
Sullivan. Judge Sullivan.
Yeah, just a process thing, because I think there are legitimately 2 motions that we are considering here. And I think people should understand that. There's this motion which sets it essentially at a $40 million reserve. I think there's a consensus among many people on the board that the 25 million reserve makes sense. And I want to make sure we're not procedurally putting ourselves into a zero sum. So either I would suggest, and I'm not a voting member, so it's a suggestion, either we make it clear that there's going to be 2 motions that are going to be done, or have each person specify between those 2 options which one they want, which I think is a better way of doing it, because then you make a concrete decision.
Will?
Just a quick question. Do we know what the EAF allocation is going to be?
Yeah, so let me let me share that slide with you, and it sort of encapsulates everything.
There were a couple
Okay.
questions that wanted to know what our total distribution is next year, to put it in context, so we did a slide on that.
Are you guys seeing this slide?
Can you make it a little bit bigger? So there's the
Sorry.
EF breakout. It's about 35 million together, but it breaks it out because partnership is 10% of the total EF.
So
right.
there's going to be a drop from 58 million?
No, the
Is that what it
EF
was?
is a one-time increase, so it's not a drop. This is base funding. This is level funding for EF. If that makes sense. When there was a 50-something million for EF, that was a one-time increase, and programs know that.
So we're talking 109 million plus this 31.6.
Yeah, so
Right.
if you go to the staff recommendation, this commission is gonna distribute 213 million, but then, you know, it's various, not all programs get all
Sure,
funding.
sure,
But everybody
the
gets
first two-
IOLTA and EF, exactly. Exactly.
Okay.
This is a lot of funds, you guys.
Yeah, so process wise, there's a motion and a second on the table. I hear what Judge Sullivan said. I think, just to be clear, I think we've got to take a vote on the motion that's been proposed. If it doesn't pass, because people take a more aggressive approach, there will be a second vote, presuming there's a second motion to. I'm going to anticipate here that someone will propose the staff recommendation, which is column B, if this more conservative approach doesn't pass.
Because I think this is important, the question that Will just asked. Can you underscore, so we're talking 109 million plus the 31.6 million.
You don't vote on the EF.
No, I
Yeah.
understand, but that's what's going
Yes.
out to the very body
Yes.
that is now going to also receive another 109 million, right? So we got the 31.6 and then another 109.
Yes.
So I think that's important to underscore that it's a very large 140 million being distributed to the organizations. Anyway, I think we need to call the vote.
But Michael, hold on. Michael, you need the right number, because the 95 is column B, but you need the reserve amount to reflect Jeff's.
Oh, okay. So we're saying reserve, a restricted reserve of 40 million?
Well, did you have to do the calculation?
Yeah.
Yeah, give me a second.
Yeah, I think it worked. I mean, it's just a projection, right? What we're actually voting on is the distribution, and the reserve thing is just a projection. So I think 40 million is fine.
But he can't do, sorry, he can't.
Yeah,
do-
so the way the 95 million was derived, Jeff, was the anticipation of taking to reserve 25 million. So we're saying we're going to take to reserve 40 million, then the distribution number naturally has to be lower.
In
That
other
makes
words,
sense.
you're starting with the reserve
Yes,
and working backward to.
yes.
No, it's the other way around. You need to start with,
No,
you need to start with what, like,
Wait, this is starting with column B in terms of revenue assumptions.
yes.
And
Correct.
changing the distribution in column B from the 100 and whatever, 9 to 95, and adding that increment back into the reserve. Am I right, Jeff?
Yes, that is correct.
Yeah, that's, yeah.
And I'm pointing out that what,
We're taking
I
B
see.
and we're modifying.
Okay. All right.
Mr. Chair,
Yeah, go ahead.
I'm just pointing out that what we're approving is the distribution amount with a projected balance, right? But that actual balance is going to be dependent upon what the actual revenue ends up being. So based on the B forecast, if we change the distribution to the 95, it calculates to a
Oh, I
reserve
see.
40, but we're not approving the 40, we're approving the 95, right? The 40 is just a projection.
Jeff,
Yes.
I have a friendly amendment. What if your motion were the column C, which would solve Catherine's and Lauren's concerns about the amount of the reserve, and it would leave the distribution at 95? And then if it turns out more money comes in, that's cool, and we'll figure out what to do with it.
So exactly to that point,
That's
Visibility at this point.
Yeah.
yeah, so the way the $25 million restricted reserve would work is we wouldn't add a single dime over that cap unless the commission choose to raise the cap. We wouldn't touch the amounts deposited into that unless the commission chooses and needs to
We don't
because
need
of
to touch that, Michael, because if we go with C, we're just saying it's a conservative.
exactly. It's just we're just going to go with a conservative approach. And then in actuality, if somehow, some way the Fed raises rates another 3 times and then more money ends up coming in, what that does is it pushes your net assets higher. So we basically would utilize that next year,
That's
right, in determining the distribution for the next year. But we're all sort of done on the reserve. We've already sort of situated it.
And if
So-
the reserve goes the opposite way, then we are protected as well.
Yes.
Yeah,
Yes.
which
So
is more likely than not.
2 things. Number 1, I appreciate and accept the modification to the motion that we are voting on column C. And the other part of it is recognizing in terms of the reserve calculation and the importance of how we adopt on the rule side in terms of the 2-year versus 3-year. So the point of my motion is that we're still providing a substantial increase and allowing ourselves the opportunity to then better define in terms of how that 2-year, 3-year cycle will work. My whole emphasis here is to help these organizations best utilize these funds, recognizing that it is at a much higher run rate than what they've been able to be accustomed to, and recognizing they can't necessarily ramp up right away. So by doing it this way, yes, we will likely end up with a higher reserve. I understand the legislative pressure of that, but I'm more focused on making sure that these funds are in the long run going to be best deployed for the needs of our community. So I am happy to amend my motion to make it consistent with option C as presented by staff.
But over a 2-year time period.
And do you want us
Over
to
2 years.
break it out? Do you want us to build it into this, or you want a separate motion for that?
I would build it into
Okay,
this.
so
And Catherine, last comment?
So I'm sorry, I'm a little, it's a little hard to hear people in San Francisco because you're kind of all talking at the same time, but I am trying to understand option C so that I actually understand what I'm voting on if I were to vote for that. And one of the concerns I have is that the projected revenue in C seems like just double what we've already received in the first quarter. And then if that's accurate, then kind of on the face of it, inaccurate in terms of using those numbers as something we could reasonably rely on. Because I thought the comment was that in the first quarter, we had already received almost 35 million.
That's accurate. And then
Well,
so the way
this shows the projected revenue is
is
go ahead.
71.6. So part of projection C is embedded into the forecast is an anticipation that rates actually start dropping in a couple of months, and they'll do it 2 times. The assumption that depository balances actually come further down. I think in the conservative approach, I want to say it was like a 45% drop. So it fits its term. It's conservative. And so I understand what your concern is, but there is a several assumptions baked into model C that leans more towards being more conservative than not. The interest rates dropping and then less deposit balances.
I mean, it seems very conservative to say that deposit amounts in between April and December are dropping 45%. I mean, my recollection of our conversations when we were working on this is that was not that likely to happen. And I guess just my final comment is, if we start reducing the amount of money available, I think it means programs have less opportunity to do the infrastructure investments that we were talking about, and having the funds set aside and sort of knowing they're there to do that over the next 2 years. And to me, the infrastructure investments about increasing salary is the most significant thing that the Trust Fund Commission could support over a period of time.
Okay, let's, is there a second to Jeff's motion?
I second.
Okay, so the
An
renewed
hour
motion,
ago.
the renewed motion.
I'll second
Yeah.
the renewed motion.
Or the amended one. Okay, so we've got a motion on the table. It's on the screen. It's to adopt the more conservative.
Chris, let's just have this one on to draft. Just make it easy.
Okay, all right. We're gonna do a second resolution for the 2-year. We'll take a vote on the 2-year plan. So let's take roll call on this motion that's before us.
So Jeff moved and Bonnie second, right?
Yeah.
Aglagi,
Yes.
Ball,
Yes.
Whitemaster, Blakemore,
No.
Bocelli,
No.
Campbell,
Yes.
Escobedo, Galkin, Iskin,
Yes.
King,
No.
Klein, Judge Klein,
Yes.
Cruz, Lee,
Yes.
Mahoney,
Yes.
Meeker,
Yes.
Milrod,
No.
Morales.
No,
I'm sorry, excuse,
that was a no. Morales.
thank you. Vargas, Alsteroff,
Yes.
Connolly,
No.
Schreiber,
What are we at?
Nine yes, 6 nays, and majority is what passes according to the new.
Yes, I would be more aggressive. I'll vote no, but it's gonna pass. So, okay, so now we're gonna do a second motion.
Okay, and the second motion is to approve this distribution and allow it for a 2-year grant.
I'll move.
Second.
We're
Can I ask a question that sort of refers back, but if it turns out that the conservative projections are way too conservative and there's a whole lot more money coming in than what was expected, this commission can amend its No?
It's too late. The process, not for next year's distribution. You can always go back, like if we don't collect enough funds, and the commission has contemplated this, cutting mid-year stream, but you don't do another distribution mid-cycle.
Yeah,
It will roll over to next year.
Yeah.
That fund balance, that amount will roll over when you decide this time next year for next year's distribution. But you don't do 2 distributions a year.
We can't amend mid-stream.
Why? So then you really have a problem with the legislature. If there's tens of millions of dollars sitting in there that are neither reserved nor allocated.
Do we have a process?
I would,
It's already passed.
I don't know, I would wanna see where is it written, you can only do 1 distribution.
Raul, can you pull up, do we do it now?
You don't have to do this now, but just saying. You know, if that happens, we're gonna talk about it again.
Okay.
So there's a motion and a second on the table to make it a 2-year period.
I'm sorry, who?
Go ahead.
Bonneche moved and then who seconded?
And I second it.
Thank you. Okay. Aglagi,
Yes.
Ball,
Yes.
Fight Master, Blakemore,
Yes.
Boshelli,
Yes.
Campbell,
Yes.
Escobedo, Galkin, Iskin,
Yes.
King,
Yes.
Judge Klein,
Yes.
Cruz, Lee,
Yes.
Mahoney.
Say
No,
She said
she
yes.
said yes, okay. Meeker,
yes.
Yes.
Milrod,
Yes.
Morales,
Yes.
Vargas, Al-Saraf,
Yes.
Connolly,
Yes.
Schreiber,
Yes.
motion passes.
I assume we'll put it in the minutes that the commission will consider longer. But
2 years.
longer than
Yes.
2 years grant, and we'll revisit that.
We'll, yeah, I'll be
Same here.
in minutes.
Okay, we're gonna take a quick 5-minute bio break and return to the agenda. And that was the biggest, I think, the biggest item, but we'll be back. And let's keep it tight since we are already at 2:30. If you can.
What can we skip is what we need to know.
Okay, thanks.
Because we're not gonna make it. Yeah, let's skip.
Item 6 on the agenda, the executive committee, and the first item there, 6.1, Erica and Erica. E squared.
I think Judge Rosie has a public comment, but I
Oh.
don't know if she's still on because
Let me see.
Judge Rosie is still on and she's raising her hand.
Okay, go for it, Judge.
I'm allowing her to speak.
thank you.
You should be able to speak now, Judge Rosie.
It looks like she's muted.
There you go.
Thank you. Can everyone hear me? Okay, my apologies. I'm
She may have had
in the car. Can you hear me now?
That's better. Yep. Go ahead, Judge.
Sorry, can you hear me?
We can.
Or perhaps we can take her public comment later when she's in a more,
Yeah, which either way
in
is
a
fine.
in
I
an easier
didn't-
place.
Yeah,
Can you hear me now?
not so much. Why don't you, when you get to a better spot, just let us know and we can.
Okay.
bring you in. Okay. Okay, thanks, Judge. Talk to you in a bit.
So, Mr. Chair, if I might, I think I received a communication from the general counsel kind of consistent with our conflict of interest policy. And I think we are to disclose that we cannot participate in a particular discussion. Did I understand that correctly?
Yes, that's my
Oh.
understanding as well.
So as a member of the Access Commission, it was determined that I might have a conflict, so I won't be participating. And I did want to acknowledge all the staff work that went into this. And so that's why I will be unusually quiet.
Understood. Okay, go ahead, Eric.
Are there any other commission members that are also Access Commission members?
This is.
Yeah, Jim.
Okay.
Great. So this item is dealing with oversight of IOLTA and EAF funds, including a proposal to develop some LRAP guidelines. So for the benefit of newer members of the commission, and just for everybody else, since I know we haven't talked about LRAP recently, a little background: loan repayment assistance programs are programs designed to help ease the financial burden of obtaining secondary education. And so a lot of times with lawyers, you'll hear about this through law schools, for example. Many law schools have loan repayment assistance programs for their graduates to help them with their payments over time. Depending on the structure of these programs, they can be tax-free, but they're not always tax-free. And it doesn't just have to be law schools. State agencies, nonprofits, they can also create LRAPs to assist with these refinancing of loans. So in 2021, a working group was formed with a focus on LRAP and loan forgiveness options. It consisted of members of this commission, the Council on Access and Fairness, and representatives from the California Access to Justice Commission. Some of the goals of this working group were to increase recruitment and retention of attorneys of color in the profession generally, as well as working on reduced turnover in legal aid, which we've talked a little bit about today already. Last year, after several months of research and working together to develop a proposal for an LRAP to assist civil legal aid attorneys across the state, went to the legislature. It was a proposal for a 5-year plan, $55 million total. And it would have been administered by the Student Aid Commission. This would have provided tax-free benefits to attorneys. So they would be maximizing the loan repayment that they would be receiving in order to pay down their loans rather than paying taxes on a portion of what they received. As I mentioned, this made it into the legislature's version of the budget, but it was eventually removed by Governor Newsom. So after that point, the working group decided to regroup, look at other alternatives, wanting to move this initiative forward in whatever way possible. And so earlier this year, when it reconvened, the Access Commission had brought a proposal to use equal access funds to allow grantees who receive state FAR funds to use their equal access funds in this way. They, reported that they would be seeking a statutory change to allow the use of these funds. The Access Commission was proposing itself as the administrator for the funds to be routed through them. And so the nature of that discussion was that the working group was supportive of doing what was possible to move forward with a loan repayment assistance option. But there were some hesitation among some members about, the structure of the proposal. Some members had announced that they preferred that the Trust Fund Commission do it because they're already the administrator of these funds to begin with, to make it more simple. But since that time, the proposal has moved forward with the Access Commission. The current status is that it had gone through subcommittees at the Assembly and Senate level and was approved. My understanding is it is in the current version of the budget. So it is likely to be in the final budget. And so that would have this program rolling out next year. The memo that we distributed talked a little bit, and I'm not going to belabor it since you just had a long discussion about IOLTA funds and the increase in revenue this past year. So due to the large increase in revenue that we've already seen and that is anticipated over the course of the year, there was discussion about whether the commission should create its own loan repayment assistance program for the use of IOLTA funds. We have been receiving requests from grantees about guidance on the use of funds because they're expecting a large increase. And so it was one option that was up for consideration. So in addition to, using IOLTA funds as they increase, it would have been seen as, perhaps a beneficial recruitment and retention tool. But staff and the executive committee are recommending against pursuing that option currently. Given the Access Commission's proposal, it could create some confusion amongst grantees having multiple programs running parallel about sort of how each is structured and what's required. And it could represent some duplication of efforts when the commission and the Access Commission could be working together. So the proposal is for the Trust Fund Commission and the Access Commission to collaborate on the on the Access Commission's proposed LRAP. Based on discussions with the Access Commission, this would involve doing a joint press release, working together to develop a webinar once it's launched to introduce this to grantees and make sure they understand its availability and what it means for them when they're budgeting. And as I understand it, the Trust Fund Commission has also been invited to participate on the advisory committee for the Access Commission. If that is the route that the Trust Fund Commission decides to go, this will require developing loan repayment assistance guidelines for grantees. The Trust Fund Commission doesn't have oversight over the Access Commission as an administrator. It only has oversight over grantees and making sure that they are spending their funds, under trust fund requirements. And so this would be giving strong guidance to grantees, no matter what LRAP program they choose to participate in, even if they have their own LRAP, for example, at their own organization. It would also create a uniform standard for now and future application. So we're recommending that the commission go with issuing LRAP guidelines, but given the timing of this, we would need to move quickly because we will be making eligibility determinations in August and proposed, budget forms will go out at the end of August and need to be submitted in September. So we would want to, by the time of the August meeting, have proposed guidelines for the commission to review and approve. So if this recommendation is approved today, staff will convene a staff-led working group to start working on that immediately.
And I'll just make a few points since I was on XCOM and supported the staff's recommendation in order to explain kind of my position on that. And I want to first make sure that we call out very explicitly the various commissioners and staff members who worked on an LRAP proposal with the Trust Fund Commission, including Erica Carroll, who has become an LRAP expert, Elizabeth Hong, who has been an important liaison with everybody. Obviously, Dwan is always our fearless leader. Brady, who's provided just a ton of legal counsel on this. Bonachet and Eric, I know you guys were in the original working group on this. And I know that Chris and Jason Galkin were also participants on the working group. And the reason I want to make sure we call those people out is because I do think it's important to acknowledge that the Access Commission's LRAP program, I think, is closely tied with the Trust Fund Commission's work. And I think it's important to acknowledge how much the Trust Fund Commission has sort of worked on this issue. Now, I will say that my understanding, and I'm a more recent addition to this LRAP issue, so I don't have the same historical knowledge as other folks that are on the commission or in the staff. But my understanding has been that, after the veto, there was a splinter, and it appears the Access Commission sort of went it alone in some way. And to its credit, it got legislative, pursued a legislative option. It seems to be getting legislative approval. And in line with the fact that an LSO or an LRAP program is very important, and there's some tacit legislative approval, and we want to reduce confusion for grantees, I've supported this request, or supported the staff's recommendation. I will say, this is my position on this, is I think the Access Commission's LRAP program should be coming to the Trust Fund Commission in the next couple of years. In meetings that I've had with the Access Commission, they have represented that they themselves are an incubator of innovative programs. And I will just note that the Trust Fund Commission has administrative expertise represented by the amazing work that the staff has here, that it has done on this and every other proposal. It is a public entity, and the LRAP program is likely to be administering predominantly public funds. But given the current status and the pending legislative approval, I'm supportive of this at this point. More generally, I think there appears to have been sort of a lack of clear communication between the two commissions about what the goals and the strategies were in particular on the Access Commission's goals. And I'm hopeful that we can avoid that in the future. And my goal is to try to work harder in making that less of an issue and to try and increase communication and try to increase candor. You know, we all have the same goals here, which is to support the legal service organizations. And I hope that we can be partners in that going forward. And that a key part of that is really candorous conversations about everyone's goals and strategies so that we are not in the position of having to do something quite urgently in the next couple of months because there was sort of not necessarily clearly laid out what the expectations were about the funds that we administered. So having said that, I voted for this recommendation at XCOM. I support it at this point, but I open it up for conversation.
Question.
Let's wait on Judge.
Can I go ahead?
Yeah, go ahead.
I noticed one of the criteria, and I wasn't quite sure about it, was the program was to assist people of color. I don't know if that was going to be an exclusive criteria for these loans, or was more that would encourage people of color to work in legal services. My concern is there have been, don't hold me to the specifics, 2 cases where the courts have struck down, I believe, loan assistance programs, one dealing with farmers somewhere in the Midwest or the East Coast. And the other one, I believe, was restaurant owners on that criteria, that was not a proper criteria. And of course, we have pending Supreme Court decision on affirmative action. We've had the California ballot propositions where the state has voted against those programs, and the overall controversy over repayment of student loans. Are we walking into programs going to be subject to a constitutional challenge, or is that really a policy, but rather criteria for the program?
So Judge Klein, I'll take a whack at that question. First, I just note that based on the recommendation, it will be the Access Commission who will create an LRAP program. All we will do is set up guidelines about how the funds that we administer can be used in an LRAP program, and consistent with all of the, we will build those guidelines out consistent with the legal obligations that we have as a public entity and with public funds. So if there's concerns about that, I think OGC will obviously provide us with whatever guardrails are necessary as we develop guidelines on the LRAP.
Thank you.
Yep.
And I'm so sorry, Judge Rosie has let me know she is only available for a few more minutes and would really like to.
Okay, go ahead. With Judge Rosie, go ahead. We'll unmute you and promote you to speaking.
Hi there. Is this better? Can you hear me now?
Yeah.
Fantastic. Great. So thank you for taking me again out of turn. I'm Judge Kristen Rosie. I'm the chair of the State Bar's Council on Access and Fairness. And I wanted to just speak on the loan repayment assistance program issue. And I think some of my comments Commissioner Connolly already said, but I do want to say that, when COAF conceived of this loan repayment program just over 3 years ago, we did hope that it would assist with recruitment and retention of attorneys of color in the legal profession, and also really reduce turnover in legal aid. With the help of the State Bar's Office of Access and Inclusion, Elizabeth and Dwan and Erica, we convened the working group with COAF and the Legal Service Trust Fund Commission and members of the Access Commission. And, we did meet for several years on this project. We were very close, as Erica just pointed out, to getting LRAP through the legislature. And we understand that the Access Commission is now advancing their own LRAP, which they will administer and hope to fund with State Bar administered funds. And while we're disappointed that the State Bar has been left out of the administration of the program, given that the State Bar conceived and shaped this program, COAF also supports the Legal Service Trust Funds Commission's effort to develop guidelines for the use of IOLTA and equal access funds. We think that the development of guidelines is necessary to ensure that the money is spent appropriately and it creates uniform standards for all the grantees. And COAF stands ready to assist the Legal Service Trust Fund Commission in any way we can with that effort. But that said, regardless of whether the Access Commission's efforts are successful, COAF urges the creation of a Legal Service Trust Fund Commission administered LRAP funded by those IOLTA funds. You know, as I said before, COAF strongly believes that LRAP will assist in the recruitment and retention of legal aid attorneys and supporting the public interest attorneys guarantees that these organizations can continue to assist Californians most impacted by the justice gap. And this initiative is part of the State Bar's mission to diversify the legal profession. And we think that there really is no better entity to administer this LRAP program than the Legal Service Trust Fund and the State Bar. And so we would urge that in the future, the Legal Service Trust Fund administer an LRAP. And we would be supportive of that in any way we could be. Thank you.
Thank you, Judge Rosie. Lauren and then Banashe.
Thanks, Chris. I can't speak for the Access Commission themselves, and I understand that guidelines will still need to be developed. But I just wanted to clarify that, you know, the LRAP program, as we conceived it when we pushed it through the legislature last year, and as it has been discussed up till now, has never had on the table any conditions related to ethnicity or anything like that. It was always meant to benefit all legal aid attorneys that have student loans. So that is how I imagine this program would be implemented. Of course, it would support the goals of diversifying the profession, but I've never understood that to be a criteria. And just while I have the floor, I wanted to state on behalf of LAC and all the programs we represent that we do support the staff recommendation here and this program going forward. I think it's going to be a huge help to programs. Trying to do 2 programs, if that is at all on the table still for discussion. One done by the Access Commission and one done by the Trust Fund Commission would be extremely confusing and administratively burdensome for programs. So we definitely support the staff recommendation to go with just one LRAP program.
Thanks, Lauren. Banashe?
Actually, Lauren, thank you, Christian. I have a question for you. What's LAC's relationship to Access?
To the Access Commission?
Okay.
We provide some staffing to the Access Commission on a limited contract, but otherwise we've have a long history of working closely with both the Access Commission and the Trust Fund Commission. In both instances, like I said, we have a contract to provide staffing on some projects.
Where do you get your funding?
Where does LAC get our funding? We get our funding from a number of places, a large portion of which is dues paid by all of our member organizations. They pay dues to us every year. We also get grant funding and a variety of other smaller funding sources.
Thank you. So I have a lot of questions on this. First, the IOLTA funds. Duan, talk to us about how, given the fiduciary duty that the State Bar has and this body has over those funds in particular, and we'll go further, how is this going to work? So as my understanding of how the Access Commission's LRAP program works is an opt-in program, right? So the legislation is going to be changed to allow our IOLTA recipients, if they wanted to opt in using EF funds for LRAP, that would be possible. We have been told that it's not exclusively just for EF. So programs chose to opt in using IOLTA, other sources of funding that they wanted to pull in. They could then remit that to the Access Commission for the Access Commission to execute the LRAP payments on behalf of the attorneys. So I guess the awkwardness, and this is where originally the staff and members of COAF and members of the Trust Fund Commission that are on this working group thought that the better entity was for the Trust Fund Commission, because a lot of we already administer IOLTA and EF. It would not be
a hardship. It would be work, but it wouldn't be too much of a hardship for us to then figure out the LRAP portion and be less confusing. However, now that it's going forward, I do think the commission has an obligation to create guidelines, to guide programs in terms of how much can they budget. Because the reality is, we're gonna release a budget in August, once the commission approves IOLTA and EF eligibility. There's a large IOLTA increase. Programs know that this LRAP is coming down the pipeline. Programs already started to come out to ask us questions. They will continue to say, what is the trust fund commission gonna allow in terms of how much can my budget? What are the parameters? So I think we're at a juncture where we need to, I think we have an obligation to partner with the Access Commission, given that this LRAP program is going to happen with Access Commission, to make it as smooth as possible. I like to think of it as two sides to a coin, right? The Access Commission will need to figure out like the logistical stuff for the LRAP program. We will then need to give programs guidance about what they can budget for IOLTA and EF. We have to come together. It's already confusing as it is. If we do not come together and issue these guidelines for programs, they won't know what to budget. They just won't know, right? They'll have kind of instructions from the Access Commissions, and the legislation says like I think the LRAP program can pay. I think if you can up to I think the IBR payment. It's not like they can just freely like, but then there still needs to be guidelines in terms of. I'll give you an example, and I think this was also the memo. If an IOLTA attorney is working, say, 20%, but the majority of their work is helping like non-indigent, is that going to qualify for LRAP for our purposes, right? Are we going to allow that? Or if they're working for more than 50%, is that going to? So there's a lot of like logistical questions that need to be ironed out to give that program. And we want to encourage their participation, obviously. So we are wanting it to go as smoothly as possible. But I do want to note that your question, that is originally why we thought the better entity to administer this would be the Trust Fund Commission.
Can I just make one point? I think those guidelines would need to be created, even if the Trust Fund Commission created its own LRAP program. So the point of LRAP guidelines needing to be created is like, whatever the outcome of today is, it needs to be done.
Yes. Okay, so then, thank you for answering those questions.
So,
No, sorry. When we began this conversation, Eric Iskin and I were chair at the time. We met with Jack London and Catherine, who were on the other side representing Access. I had a problem, and I brought it to Donna at the time, that I couldn't understand how we can have someone who sits on our commission here at the Legal Services Trust Fund Commission and represent and chair or vice chair or be in leadership in this other body. I was told then that this other body, being the Access Commission, was a policymaking arm. It's a think tank of sorts, and that's where their focus is. When Rich and Kim then became chair, there was another issue, an issue of Access. Catherine and Jack and et al. Were trying to go after a $5 million grant, which then started to beg the question, are they a grant-making body or are they a think tank? Now we're talking about additional funds somewhere we're looking at these dollars. We just came out of the last agenda item. Somewhere, I don't know, give us the figure. What is the amount that we're talking about that's going to now be rooted to a think tank to make grants? Do you have a sense of what that amount might be?
I'm going to make a point that the LRAP program is not a grant. That the LRAP program is neutral. I'm not the Access Commission, but I just want to make sure we have the facts on this. The Access Commission's LRAP program is neutral as to the sources of the funds. I acknowledge that the vast majority of it will come from IOLTA funds, we think. But if there were other grants that also allowed for loan repayment, that they would accept that. So I'm not trying to say.
So who receives the application?
You mean for the loan repayment part? I assume the Access Commission.
Okay, so then how do they go about? So is it our guidelines they're going to deploy?
No, we will deploy our guidelines about how our money goes and is used in an LRAP program.
who oversees how the funds are being used?
You mean once it's, once
This
once
is my
the Access
problem.
Commission?
Yeah.
I'm going to just make representations that were made to me. I am not the Access Commission, okay, so. So let me just make that point. But I would say that my understanding is the organizations would apply to do an LREP, to use the Access Commission's LREP program. And then the employees would submit their receipts for their loan repayments and then would receive a reimbursement of the amount of their loan repayment through the Access Commission. And then there is a plan in the hopefully near future that in lieu of the employees paying out in advance and then getting reimbursed, that there would be direct payments from the Access Commission to the Department of Education's like student loan, CERD. Staff may understand this a little bit better than me. I'm not saying I'm against what you're going for here. I'm just trying to make sure we have all the facts so that it's clear what's happening.
No, it's important, it's important.
Yeah.
The crux of this for me is if we're trying to work as two commissions on the same aim, I think we all are on the same page on that. We support those aims. That's not an issue. If we're trying to mitigate confusion for the grantees, I think we've already started that confusion because we are the grant-making body, we're the oversight body. This is what we've been doing for decades. This isn't what they do. Now, I understand that at this point, they have one of our former staff that was terminated years ago, Stephanie. So maybe she's going to be helping with some of this oversight. I'm not sure. But I'm really concerned with how this is going. I'm concerned with the commingling of commissioners there and commissioners here. You stated a moment ago, Erica, that we don't know how the legislature ended up accepting the verbiage that we're now understanding by potentially Access had some conversations or someone had some conversations with the legislature to be able to push this through. We know that it wasn't the state bar that had those conversations. So who did? If we are working in partnership, why weren't we at that table? If we are trying to find ways to work together, why aren't we at the table? There are a lot of questions that I have, and I've been concerned. I've expressed my concerns, and I'm doing it now publicly. I've expressed them to Dwan. I've expressed them to when I was chair, with every chair that has been there since I was chair, that I don't believe that we can have commission members on both commissions and there be a true, from a governance perspective, a true fiduciary duty of loyalty and care. And we've already seen that someone has gone around the state bar and has moved this legislation forward. So, and on top of that, it's the IOLTA. It's the IOLTA money. We have a fiduciary duty on that IOLTA money. 27 employees we have here at the state bar. I support what Kristen said. I support what Erica has said. We can stand this up. We should be the ones to stand it up. The staff have done the mammoth work on the research around LRAP, and I know that Erica, you were being generous and reducing how much the staff is actually generous to Access and reducing staff's work on this. It's been primarily the staff of the state bar. So these are my concerns. I don't have any. I'm not getting answers. I have more questions than answers, and I'll
Yeah, go
I'll
ahead, Jeff.
yield the floor.
Yeah, go ahead, Jeff.
So my question comes from a perspective of representing the banks that are providing these IOLTA funds. And it's done through a program which the banks understand specifically is to be managed through this body that has particular governance to it. And I guess my question is, to the extent that now those funds are going to be moved through a different entity, to what extent is the bank lobby engaged in this, and has staff considered potential impact for our leadership banks that may not appreciate the fact that the funds are going to be dispersed through a different entity?
Considered the impacts on banks. With IOLTA funding, we have allowed programs to fund for their own self-administered LRAP, and this is going to be a technical distinction. They've done, and there are programs that have opted into that. There are a couple of our larger programs that have had an LRAP program for years. We have let them budget for it. We've considered that as salaries, so that's always been kind of qualifying for the purposes of IOLTA. We would treat EF the same way once this legislation passes. And here's the technicality. If the program is going to cut a check to another organization and it's not a self-administered LRAP, where the line item that it would actually go in is contract for services. That line item that's on our budget for contract for services is definitely very scrutinized with the staff, and we elevate things that like are large in it, right? Because usually it's clumped together. Patients knows this. Programs have to itemize it, so we know where they're funneling the money, right? That's the fiduciary duty part. So in this instance, what we would want to do is separate the LRAP, because now it's done in more systemic. So we imagine large increase of IOLTA, a lot of programs are going to be opting to it. It's going to be a large amount, which again, we support that and we encourage the LRAP. So what I would suggest and this is when we develop guidelines and we'll come back to the commission, let's separate it out, have the programs budget for just specifically the LRAP piece that will go to the Access Commission. We can get a handle on how much it is, we can track outcomes, we can do all that good stuff. And that's why we think we need to develop guidelines to have that still foothold on like our fiduciary duties, the IOLTA. But Jeff, to answer your question, we have not thought in terms of the impact of the banks. It did not occur to us that there needed to be a moment where we needed to communicate that to banks, because we have not communicated that to banks when we have allowed programs to budget for other instances.
So I just note we have a resolution in the board packet for us to vote on. I think the sort of core decision point for the commission today, and I want to sort of bring our focus back to this, is that really the commission is telling staff to develop policies based on an outcome that we assume is going to get through in the budget process. So I don't think, having heard sort of, I will say, criticism or commentary that concern, which I agree with, in terms of what was optimal or what is optimal from our perspective. It doesn't really change what we have to actually do today, which is to direct staff to develop, in the event that the budget goes through as expected, guidelines for programs. So it also doesn't really change or alter in any way what our obligation is as a commission to oversee the appropriate utilization of IOLTA money. So our mission really hasn't changed. And the task today is, I think, pretty clear before us, whether we agree or disagree with the decision of the legislature. I think we have an obligation to the programs to provide some guidance. So anyway, I'm going to do 3 quick comments, but I do think we just, in the sake of time, it's already 3:05. We do need to move on. So Lauren, Will, Jeff.
Thanks, Chris. It was suggested earlier that there would be some confusion on the part of programs from having to go through this Access Commission program for an LRAP. I just wanted to dispel that notion. While I've heard from programs that it would be burdensome to have to deal with 2 programs, I don't think that programs really care much where they have to go to get this program. They need an LRAP program. They want an LRAP program, and that is what's important to them. And I think that there's a lot that can be discussed about who will ultimately administer this, why it's being done the way it is now. I think there's a lot of things we could discuss about context and feelings about the state bar at the legislature currently, which is unfortunate because I don't think that is a reflection of the excellent work that the state bar staff in the Office of Access and Inclusion does. But I think that that's all water under the bridge. Speaking on behalf of programs, I really want to encourage you all to keep your focus on what the ultimate goal is here, which is to ensure that programs have access to an LRAP program. They need it to help them with the recruitment and retention crisis. And so I hope that we can get to that goal as quickly as possible, in spite of what other feelings may be had about the process by how we got to where we are.
Will?
Thank you, Mr. Chair. I see two pieces to this resolution in the memo, but I guess they both boil down to there will be an LRAP program that uses IOLTA and other state funds. Is that accurate? Is my understanding accurate there?
I mean,
that's what we have to
it's
vote on?
anticipated, yes. Yes, it is anticipated, yes.
And so the only question is whether, if the state grants funds, if they put it in the budget, then the question is whether we're going to be involved in that process or not.
Well, I think we will be involved statutorily one way or another because we have an obligation to ensure that the IOLTA funds are spent appropriately. So under any circumstances, if we decided not to act, we're going to get these questions and there will be a need from staff's perspective to actually address questions raised by the programs.
Okay. Okay, so, and this isn't a change, we're not changing what's a qualified expenditure, this, and, okay, thank you.
Good questions. Thank you, Will. Jeff?
Thank you, Mr. Chairman. I had one additional question, and that is, to what extent are the administrative expenses going to be different by having more than one commission engaged in this effort?
I think it remains to be seen. I don't know if staff has anticipated or projected anything. I mean, I think the short answer is it will be less efficient.
I think if the state bar or the trust fund commission wanted to administer the LRAP, we would fold it into our existing admin. It wouldn't be an increase.
The Access Commission, it will be receiving $250,000 to administer it. So I'm assuming that's the amount of money that it would take for them to administer it.
So if the trust fund commission was to just do it directly, then we would be saving that 250,000.
Well, the state would be.
No,
Well,
not
no,
necessarily,
yeah, I
because if it's in the budget and
Yeah.
the Access Commission, like if we decide to set one up, it would be alongside the Access Commissions, because there's no indication that the Access Commission would not continue with its LRAP program, just to be clear.
Yeah, we have to assume that that's gonna happen at this juncture.
Yeah.
I think it's getting voted on next week. There's
Because why?
budget trade.
I think that's important.
The why?
Why?
The why is that we've been updated. We know there's corollary, an SB 101 and what is it, AB 101, they mirror each other, have it in there. There's right now a budget trailer language that has it in there. There's been no indication that it will not be approved. So I think we need to
And what's the
work on that.
language of that bill? Or
What's the budget?
It's a budget.
Yeah, what's the, do you have a language?
I'll look at it.
Yeah. Did you have?
Yeah, so I do want to respond to Lauren's point about the confusion amongst like between the Access Commission and the Trust Fund Commission. And I think that the confusion is what really like propelled the staff to change its recommendation. But I do want to note for the record, because I've been feeling really uncomfortable by this, is that, you know, the Access Commission a few years ago did receive the $5 million of innovation grant that I think Bonachet is referring to. And at that point, there was a lot of confusion. There was a lot of confusion about why the Trust Fund Commission was not doing it. Programs that firmly came to Elizabeth and I at that point, that Legal Aid Association of California did not advocate for that money to go to the trust fund commission, the state bar, and there was no acknowledgement of confusion that when that happened. We didn't say anything because obviously we support innovation grant, you know, but there was a lot of confusion. There continues to be confusion. And so I do feel a little bit like it's insulting to use confusion when there are entities that you want it for your way, but then that wasn't acknowledged when there was another body that was also standing up, a grant making body. And that confusion definitely is what is driving the staff to kind of save the programs from. But there wasn't that same, I guess, courtesy acknowledgement when other sources of funding were being built. So I just definitely want to set the record straight for that.
Hold on one second. Do you have it?
Yes.
Yeah.
So it says, in order to improve equal access and the fair administration of justice, $250,000 shall be annually appropriated in Schedule 5 by the Judicial Council to the California Access to Justice Commission to administer a tax-advantaged student loan repayment assistance program for service providers employed by qualified legal services projects and support centers. The amount of each loan repayment assistance shall not exceed the payment amounts due from any individual participant under the lowest repayment option available from the student loan creditor.
Do we have two questions? Do we have a sense of how much money we're talking about from not the IOLTA? And it's interesting that it's directly pinned as to it's the Access Commission. So how did that happen? But secondly, what do we know the amount we're talking about as it relates to IOLTA?
We don't know because it's an opt-in, so programs have to opt in.
Do you have a sense?
We have
of the number?
figures based on what Erica's research. Erica sent out a survey to kind of figure out how much loans from legal aid is in the system. So I don't know, there's some figures there. Is it in the ballpark of 10 million? Or am I just drawing a number?
At the time of the proposal last year, 10 million was assumed to cover every legal aid attorney's needs throughout the state.
And in our discussions with the Access Commission, they have thrown out a number about maybe 5 million for annually.
So it's anywhere from 5 to 10 million?
As a projection.
As a projection, we don't know.
You know, this isn't for this very resolution and the vote, but I have been asking for the last 3.5 years, and I'm gonna now publicly ask it again and leave it on this table because, you know, Christian and I are gonna term off this year. Jeff is soon thereafter. I don't know how much longer, Erica, you have. And those of us who've been around from Appendix I to now, I will tell you as a senior member of this commission, I am more concerned today than I was even around Appendix I for the future, the existential question of this commission as it relates to the Access Commission. And I've asked this question before and I'm asking it again. No need to answer. It's just for all of you who are still going to be here as commissioners to think about going forward. What is the end game for the Access Commission? Why the compiling of the funds? What's the game ultimately, given that we as the State Bar Legal Services Trust Fund Commission are the entity, have been the entity that the state has entrusted with these funds. The legal community, lawyers, law firms have entrusted with these funds. Banks have entrusted with these funds. There are ample constituencies, as well as what we've been able to produce in terms of grant making, efficient grant making for the community. So I really, you know, and I know this is a public meeting. I know we are on Zoom. I know this is being, you know, recorded. I want to go on record for that very purpose. I don't understand what the end game is, given that this is supposed to be a think tank. It's supposed to be a policy arm to support the community, the legal service trust fund community, and we have been working that way together And now this seems like a fork in the road. So if you need to look at the resolution.
Yeah, I will at this point entertain a motion on the resolution that's on the screen, which represents staff recommendation endorsed by executive committee.
I'll make the motion since I was one of the people who voted for it in XCOM.
Is there a second?
Second.
Thanks, Will. Okay, let's take a vote.
Okay. Agwagi,
No.
Ball,
No.
Fight Master, Blakemore,
Oh, well,
She can't.
yeah.
Stain,
Basheli,
Yes.
Campbell,
No.
Escobedo, Gulkin, Iskin,
Yes.
King,
Yes.
Judge Klein,
Yes.
Cruz, Lee,
No.
Mahoney,
No.
Meeker,
I have to recuse because I'm a lax appointee on the Access Commission.
sorry, I have to redo the vote. I logged it wrong. I apologize. Agwagi,
No.
Ball,
No.
Fight Master, Blakemore,
Same.
Stain,
Basheli,
Yes.
Campbell,
No.
Escobedo, Gulkin, Iskin,
Yes.
King,
Yes.
Judge Klein,
Yes.
Cruz, Lee,
No.
Mahoney,
No.
Meeker,
Recuse as I'm a lax appointee to the Access Commission.
Milrod,
No.
Morales,
No.
Vargas, Al-Saraf,
Yes.
Connolly,
Yes.
Schreiber.
Wow.
Okay. One,
What?
5 yes, 7 nays. Is it, I'm sorry. 5 yes, 7 nays.
Yes, that doesn't matter.
By 6? I'm sorry.
Either way, it doesn't matter. So the resolution does
I'm
not
sorry,
pass.
6. What, are you
Can I
voting?
Yeah. voted
ask
no.
a
In any circumstances, it becomes,
So, sorry, 6 yes, 8 no's. Can someone do a double check for me? Just 'cause it's
Sure.
vote. I had 7. 6 yes, 7, 8 no's.
yeah, and
So what happens now? At this point, what do we know?
So you're not gonna have guidelines we voted against doing guidelines. So, so just as an FYI, so if the Access Commission stands up its LRAP program, we will not have guidelines
yeah,
to deal with that LRAP program. I just want to make clear that's the implication for this. We can progress.
yes,
Well-
sorry, is my phone recorded as a no? Did I say?
Yeah,
no?
you said no. Or
Yeah.
did you say yes? Did
I
you say
said,
yes?
I meant yes, I apologize,
okay,
but it
hold
doesn't
on.
matter, because it's still 7-7.
But we should have for the record.
Yeah, for the record,
For record. So
yes,
you're yes?
yes, but
It's 7-7?
you
So
need a
it's tied?
majority. Yeah, but you
You
need
need
a
a
majority.
majority, so
Yeah,
it's.
it doesn't pass.
Is that, Raul, can you do a check for me? I'm sorry, right, majority, we're at 7-7, I'm sorry.
Yeah, I think that's right.
Yeah.
Let me confirm.
Yeah. So, okay. The
I have
answer,
a brief
we can't
question.
really spend any more time on this, so
Can I ask just a really brief question? Would the first part of the resolution be acceptable? Just to develop guidelines if the state issues us money, would that be acceptable? Or is that still objectionable? Because I think that part seemed less objectionable.
That was the objectionable part.
Oh, then I misunderstood. I thought it was, okay, sorry, thank you.
So I want to answer the question, but we do have to move on. I mean, the reason why I voted yes is because I do think whatever repudiation and no vote is intended to signal, we are left with questions that are likely to come to the staff, which will not now spend time developing the guidelines absent a different vote. So that's the answer to your question. And I think time will tell what that means.
So it seems the real issue is the Access to Justice Commission is stepping into work that we normally would do and should do. So I don't have any idea what, you know, I heard there should be better communication, people should have more candor and whatnot, but why are we talking to the ATJ about why don't we?
The ATJ is in the room.
Well, I hear that, I know, but in an official kind of like, you're gonna get, legislature looks like they're gonna do
We've
this
done that
in
multiple
the
times.
budget, okay, so that's what I'm asking.
That
Is
we've
like-
done that multiple times. Every chair has done that.
And, but with respect to this particular issue,
Well, this is all somewhat fluid because it has come up in recent weeks. So I think the idea is that if the money gets put into the budget, the program gets stood up, and programs begin utilizing an LRAP program with the goal of using IOLTA money to pay for the staff that would benefit from it. Questions will come back to us as a commission about how and what is an appropriate use of their IOLTA grants.
totally get all of.
So,
Yes.
We're
yeah,
not gonna know how to budget. I'm also really struggling myself. Though I appreciate the, you know, the what transpired. I am struggling because the practical is like,
Yeah.
program is gonna be like, I wanna opt into this. Where's the line item? I put it in staff.
And how do I know what's the appropriate use of IOLTA, the EAF?
yeah.
So, well, in the past, this has been an acceptable use of IOLTA.
But here, that's what I'm saying, this is the technical difficulty. In the past, when it was a self-administered, if a program runs their own LRAP, it is counted as salaries. When a program cuts a check to an outside organization, we count it as contract services, and that line item, because money is going out, our money is going out, it gets heavily scrutinized by the staff and the commission. Rightfully so, this is our money being spent on another entity, right?
Right.
So the difficulty is like, yeah, if this were to be a working group, would the staff recommendation be like, let's pull this out, let's count it, because you know, philosophically it's salaries, right? So let's pull it out, let's count it. Without that type of conversation, I don't know where we are left at, the staff, in terms of, we will leave things status quo, but how are programs gonna know what to
So,
budget for?
let me just, Judge Rosie
Yeah.
said, you know, we think this should come to the trust fund commission. I don't know if who she's speaking for, if anybody.
Co-op, that's our sister
That's the
organization.
other side of the office access and inclusion that we are on one side of.
So what I'm trying to get at is, there doesn't seem to be big opposition or conceptual, like never, that will never, it seems like people are seeming to agree that this entity is the entity that should be administering this program.
Which entity?
And that this trust fund commission.
Right, but the legislature.
I
has
know
a
that, I know.
Yeah.
And so the question is, how do we get from what the legislature is doing to what ought to happen? And just with respect, I hear that
There shouldn't have been,
there's history,
Yeah.
I don't know
there shouldn't
about-
have been any backdoor
But you know,
dealings
that was
to
in an
place
email.
themselves in the
Right.
bill.
I
There
think-
should have been the
yeah,
Legal Services
the
Adjustment
answer-
Commission placed in the bill.
Yeah, the answer is that it's sort of beyond the call of this meeting, but it's dialogue with the legislature is the short answer, and how to arrange that and coordinate that is sort of more than what we can accomplish today. So we are going to move on.
Just Amin has his hand raised. I
Oh,
don't know if you
go
want to
ahead,
take that
Amin.
or not.
Yeah, go ahead, Amin.
I'll keep it brief. Given how close the vote was, and given some of the sort of follow-up questions, I think it might be helpful perhaps to clarify this concept that we don't have control over whether the funds are going to be allocated to this. And correct me if I'm wrong, but my understanding is we don't have that control. We can't say yes or no to whether the funds are going to be allocated. The only question is, are we going to be involved in how those funds are used and in what way they're being used? So I don't know if that helps clarify for folks who may have voted no on this, but if it does, would it be appropriate to reintroduce the motion for a revote?
I mean, I don't know if there's,
Can't go back.
well, no,
You can.
yeah, we can entertain a new motion.
Yeah.
I don't know that, I mean, I don't know that anybody's prepared to change their vote, but.
Is there anybody, if the motion were bifurcated, would that change anybody's vote? Because I don't want to waste anybody's time. But
I don't think it's a bifurcation is what I'm hearing.
Yeah, I don't either.
It's the implication, I think, that by developing guidelines, we are working in partnership with the Access Commission and supporting their program. That is, I think, the contestable part of it. Is that correct?
Some of it.
Right.
I
The
guess this-
second part is actually a part that I think a lot of people who voted no would support, which is, you know, whether the trust fund commission did it themselves. So I just want to.
Go ahead, Amy.
I just think that we're running into an issue of whether we are satisfying our obligations, I think, by not being a part of this process. If we're not creating those guidelines, I think we are running into a situation where we are potentially in violation of our fiduciary obligations with respect to this money. So I don't know if that helps reframe this, but that's how I'm viewing this. I appreciate the background. I appreciate the concerns, and I don't want to minimize that in any way, but I do think that we have kind of a clear mission and clear guidelines, clear obligations as trust fund commissioners with respect to this money. And I think we do, to the extent that we can, have an obligation to stay with the money and follow it through to the ends to make sure that it's being used in the right way.
Well, I mean, I'll take a straw poll. I don't know if anybody is prepared to change their vote, which would flip the majority, but having heard that, unless somebody's going to identify themselves and then make the motion again, I think we got to move on. We have a lot to cover. Time is running out. So I don't see anybody.
So I know we don't call we have the 4 meetings, we have 5 meetings this year.
We're gonna end up calling.
Yeah, so
I agree.
after this meeting, I'm going to send out another poll for a meeting next month. We have to revisit this. The thing is I feel strongly in the message that's being sent. I agree in the message, but we need to roll back and figure out a way how to work through this, because this is going to cause a lot of confusion.
If we don't work on guidelines and issue them in time for the budget season, the commission will have to, a lot of things will be elevated to the commission next year, because staff, we won't have any direction to provide the grantees.
So basically what staff is saying is that we're not excited about this either, but we are in a, we've been placed in a corner. And that now the commission is also placed in that same corner that has to basically approve this.
But, and I mean, we're deadlocked, right? So I think we should meet. I don't think you guys are prepared to make a decision. I think there should be a commissioner or two that talks to the Access Commission in this meantime.
I'm interested in doing that.
And try to figure something out and bring it back. That would be my recommendation, but I'm just staff, so.
I mean, I agree, but
I'm also interested as someone who wants to improve the relationships between the two
There we go.
organizations and be more effective.
so we've got 2. All right, yeah, I mean, I feel you.
Work cut out for us.
I agree with you. All right, next on the list.
There's no shame in changing your mind. If that helps.
I mean. Thank you, me.
All right, Erica, 7.1. And I guess as much as I hate to be a taskmaster now at this late hour, but Oh, shoot, sorry, 6.2.
Just really quickly on the appointments process, the commission itself has one appointment this year, is the client eligible position. Which our board of trustees has 3 appointments, that's going through the cycle. They have received recommendations from their appointments liaison. I will notify you as soon as they vote in a couple weeks, but we need to deal with the trust fund commission appointment. Last year, there was not a nominations committee that was disbanded. The commission went in the route of having 2 representatives from the commission interview the candidates and alongside with myself, and then we came with a recommendation to the commission. The executive committee is recommending that the commission take that same course and would like to put it out there for volunteers. Last year was done by both members of the executive committee. This year, one needs to recuse himself and another one is applying to the appointment. So there's a conflict there. So they would like to encourage 2 members of the commission to volunteer to interview and come up with a recommendation. So I can take the volunteers now, or you can email me after. And there's more than 2, then Chris and I will decide on who.
But everybody jump for one.
I don't think I can volunteer on that one.
All right, reach out to Dwan if you're ready to join me on the interview committee or interview group. Okay, Erica.
So just 2 items related to the eligibility and budget review committee. The first one is audit related issues in the 2024 IOLTA EIF applications. So staff has begun review of applications for 2024. They came in on May 15th, and we're in the thick of that process of reviewing them. An essential part of the application is applicants need to submit an audit or a reviewed financial statement from their prior fiscal year. And it needs to come in with their application. The deadline each year is May 1st, but staff does have discretion to grant